Yes.
May I have your lordship's kind leave to move on urgent matter with leave of your lordship on Tuesday or Monday? The urgency is the West Bengal government started a scheme.
Yes.
The West Bengal government started a scheme, Akanksha housing scheme, and we are being retired government employees were allotted flats under the middle income group. We got that. We had the common areas of the concrete road and the park. Suddenly, my lord, the housing department have come up with a notification that for the higher income group in our common areas, they will construct a garage, and for that lottery has been used. Our ingress, egress, everything will be stopped, my lord. And a lottery notice has already been issued, my lord.
Very well. Not so much of urgency there.
Tuesday, at least. Otherwise, my lord, if this has been allotted again to those persons, then again a right will accrue, my lord.
Nothing will accrue. Very well, Tuesday. You serve notice in the meantime.
Lord, may I have your lordship's kind leave, my lord, to mention a very urgent matter, my lord. I did not wanted to disturb your lordship, my lord. I went to court number 7, having irrespective of classification determination, but my lord is not sitting from my lord next week. My lord, that's why I'm disturbing your lordship. My lord, this is a ready for hearing matter. The problem is, my lord, this pertains to my lord fish market of Howrah. Now, my lord, there were certain stalls which were left vacant.
If the honorable judge is not sitting, somebody will have urgent determination, isn't it?
Lord, urgent determination, those are for irrespective of classification. Those, my lord, do not have urgent. Else, your lordship has the main determination.
Yes.
That's why, my lord, your lordship determination, when your lordship is not there,
Yes.
will have. But because
Then,
the only difficulty is, my lord, I don't have any other forum to move this matter. Lord, the urgency is, my lord, the KMDA is, my lord, granting stalls to all other, my lord, third parties. My lord, my writ petition will become infructuous. That's the only difficulty.
Why will your writ petition become infructuous?
My writ petition pertains to, my lord, with respect to an assurance and undertaking given by KMDA in the 1980s, whereby, my lord, we were allotted one shop room. We were told when the shops will be allotted, each of you will get one shop room each. So vacant shop rooms were there. Now, my lord, for seeking those shop rooms, my lord, I came up before this honorable court. KMD at that point of time said, we are immediately not taking in steps. So let affidavits be filed, we'll come back. My lord, reports were filed, affidavits were complete. My lord, till they did not do anything. Now suddenly, my lord, this week they started, my lord, allotting notification that by 20th of August, they will complete this allotment.
The one that is pending in your writ petition?
Yes, all.
All right, you file an application.
That I have done. That's exactly what I have done.
Right.
That application I want to move. Lord, kindly, my lord, before 20th August, my lord, I will not say tomorrow, my lord, day after tomorrow.
I'll take up applications on Thursday. You give the number.
Yes.
Thursday it will appear. And please communicate this to your other side.
I'm obliged.
May I mention a review application?
May I permitted to mention with extreme urgency, I am mentioning the matter. Order of physical possession of my property was expired in the month of March. Thereafter, learned court below extended the time to validity of the said order. In the meantime, the order is not extended by the authority. In the meantime, on 4th, the authority along with the huge police personnel come to my house and take over my property
Possession.
physical possession, and thereafter I indicated that thing, the said order is not in existence. Thereafter they mentioned that they will come within 6 days to physical possession of my property. Lordship, kindly take this matter next week, Tuesday or Wednesday, any day, so that my client will.
Very well, Wednesday it will be taken up. Serve notice.
The Lordship.
The Lordship's kind leave to mention one matter, Lordship. This matter is running in my Lord's list as item number 47. Now, Lordship, an emergency has cropped up, Lordship. We have received a notice from the bank as to there will be a physical possession of the property be taken on 12th August, that is coming Tuesday. So, Lordship may kindly take up the matter on Monday, Lordship. It's based on emergency, or else I'll be evicted from my property with my family and
Surface proceeding.
my Lord. I'm led by Mr. Shuddha Banerjee in this matter.
Whoever is leading you is not important. The matter is important.
Already talks of settlement were going on with the bank. My Lord has recorded that as well.
Yes.
In the meantime, they have issued such notice and
Maybe if talks of settlement is going on, you can
we have given,
proceed.
my Lord, multiple proposals. We have increased it to a level of 1 crore, my Lord.
It is not for the court to decide as to how much you will pay and how much the bank will receive.
Lordship, I
It
understand.
is absolutely the bank's prerogative how much they will receive. If you are aggrieved, rush to the tribunal. Why over here?
Lordship, that
The
exceeds
court cannot
jurisdiction
force
of
or
the bank.
compel somebody to enter into a settlement, isn't it?
Lordship,
Then
I bow down, but Lordship, it's 12th August, Lordship, the possession of the property will be taken.
again 12th, if it is taken, it will be taken. You have not paid the money.
I have your lordship's leave to mention a matter, my lord. A similar matter is being heard before a different bench, my lord. We are seeking release of this matter so that it can be tagged there, my lord.
Yes, sure. Which is the item number? Is it there in the list?
Written there in the list, may I? On
If-
Monday, my lord, if it can be.
Yes. Provided the file is available,
The file
otherwise
is
the
there, we have ascertained the file is
all right, then it can be done.
very grateful, lord.
No, my lord, my lord, it's an application for contempt. Yesterday, this matter was appearing as item number 299. Now, my lord, the difficulty is this contempt matter, your lordship is allowing upgradation and mentioning.
Yes, 299.
Yes, my lord, the
yesterday.
difficulty is this, lordship kindly see, my lord, I am not putting blame to anybody. My lord, first occasion, this matter was taken out of turn on 6th of March due to service of notice, I understand. After service of notice, my lord, on 10th of July, the matter appeared as serial number 420. Somebody mentioned your lordship has passed an order without an, my lord, no intimation was served upon me. Yesterday, it was again mentioned, your lordship, my lord.
Who are you appearing
My
for?
lord, I am one of the for one of the alleged contemners. Now, my lordship, kindly appreciate my difficulty is this. Since I am representing the state, I am also answerable to somebody. My lord, the question is being put that repeatedly why I am not appearing.
Yes.
This is the difficulty.
Right.
So, my lord, they are mentioning lordship kindly, my lord, with folded
Yeah.
hands, my lord, I am requesting
The
this.
matter has not been signed as yet.
My lord,
You please bring your other side.
my lord, will your lordship be kind enough, my lord,
At
to
1
is
p.
this at
1
to be mentioned on Monday, my lord? I will serve
all right.
notice,
To be
formal
mentioned.
notice.
Yes, to be
My lord,
mentioned on Monday.
my lord, grateful, grateful.
Give the number.
My lord.
299. Yes.
Of today's list, my lord, it is wrongly marked as assigned matter, my lord. This is a hearing matter appeared before your lord.
It's not assigned.
No, my lord.
Check up, please. Yes.
Ma'am,
My lord, extension of interim order, my lord. Give and slip. My lord, one thing, my lord, it is expired, it already been expired on 31st, but matter is in the list, my lord, appearing as item number this. Because of the sudden illness of the advocate on record, she could not mention the matter for extension.
But then once the interim order expires,
But
then a
it is in
formal
the list, my
application
lord.
has to
My
be.
lord, I have served up on the other side also, my lord, kindly consider.
Very well. Extension of interim order Tuesday it will appear. Serve notice. Yes,
My lord, I have served notice.
Tuesday.
My lord, I have mentioned yesterday. My lord, yesterday I have mentioned because my name was not included as respondent number one.
My lord.
Do not get so agitated. Her name has not been recorded in the order. Who are you appearing for?
My lord, respondent number one, Union of India.
Union of, please come.
Lord, I am for Reserve Bank of India.
The matter has appeared in the list under the heading to be mentioned for incorporation of the name of the learned advocate who represented the Union of India before this July 2025. Due to inadvertence, her name was not recorded on the said date. Be it recorded that such and such learned advocate represented the Union of India before this court on 30th July. Let this order be read along with the order dated such and such.
Lord, I'm appearing for the petition of Lord.
All
Great.
right.
But I have been instructed, though I don't have the brief. Lord, I have
Read
been,
the first date. How
Yes.
can you
I
appear?
have been instructed to appear.
Hmm.
So if your lordship kindly directs to,
Who is this person?
He was a petitioner number 2 in the writ petition. The tribunal had reduced the valuation. My lord had directed refund.
Hmm.
Nothing has been done. And
Both
instead,
are not coming. It is one is coming. All right.
two brothers,
Two
the
brothers, one is coming.
one said he will not pay advocate anymore. So
Serve
yes,
additional copy upon Mr. Mukherjee.
get a copy there. I mean,
आप दो आप ओखाने आप ओखाने.
just
12th of September.
12th of September.
But now, the notice of demand has been issued on basis of the enhanced valuation, which was reduced by the tribunal. So we can apprehend the worst, my lord. So
Precedence. 12th, 5th. All right. 29th of August. 29th August.
देखिए একটুখানি আমার premises আর accessory ব্যাপারটা
I appear for the petitioner, my lord.
Stand for the respondent bank.
Yes.
Please kindly sees the last order dated 17th of July 2025. Now, this is a writ petition, my lord, seeking quashing of an order, my lord, declaring the company's account as fraud. There are violations on at least 6 counts which are there. The most elementary being that there is no constitution of the committee, the identification committee.
Has the report been prepared?
No report has been filed.
No,
There will possibly not be any report because the document speaks
Let
for
me
itself.
hear.
I'm praying for 1 week time to prepare the report.
Why?
It's not ready yet.
17th July, the order was passed.
Yes, Lords, I understand, but it is not ready. I'm praying for 1 week time.
Will you be able to prepare it within a week?
Yes, Lords.
Don't fail this time. Please come. On the prayer of the learned advocate representing the financial institution, time to file the report stands extended till 20th August.
May the interim order be extended in the meantime. It's expiring on 14th of August.
Release the matter for further consideration on 28th August. The interim order that is subsisting is extended till 26th September 2025 or until further order, whichever is earlier.
I'm grateful.
Lord, I'm for the petitioner. On the last occasion, your lordship directed production of
The deed is there.
deed
They are supplying the certified
for
copy.
the second time.
Certified copy?
Yes, sir. That was the direction we have also.
Check up, please.
Yes, please. Deed number. Lordship will find the deed number at the third page. It is there in the deed. May I supply your lordship a copy of the deed? Is that? Number deed number आगे पता है जेटा
You check it up.
Yes.
Come back on the next day.
Lordship,
Alright.
only once, 1 minute, not even one.
All right. If the council is satisfied, then the court doesn't have any issue.
Yes.
This deed is different from that.
Yes.
Your lordship.
What happened?
Satisfy yourself first. Then only the court will dispose.
May-
Is this the only prayer that you have?
Actually, I have submitted a particular deed,
Yes.
and this deed is at variance from that.
Yes.
Check up.
Thank
Come back.
Lordship.
Please come.
Simply-
So, copy of the certified copy of the subject deed has been produced by the learned advocate
Only records, your
representing
lordship.
the
Only
state
records that
respondents.
the deed which was sought for, that deed number, because the subject would be different.
Give the deed number.
The deed number, what was the deed number?
Put it in a piece of paper and hand it over, please.
Yes.
Subject deed জায়গায় যে ডিডটা বলছে সেটা
May I-
দিয়ে দেবেন.
May I keep a copy with the record? Your lordship?
Please do.
Yes, that will be better because this will reflect the deed number as well.
All right.
This is better. The same deed number is.
Deed number is same.
কোথায়?
There cannot be probably two deed.
Is it 7648?
Yes, yes.
7648?
No, this is 8. Only 8. Deed number is 8.
How can deed number be 8 only? 76 na 7548.
Deed number 8 of 1960.
Lordship, let him come back, Lordship. Let him check.
I don't know whether this is genuine also, but
Well, it's coming from the state. Why will you disbelieve the state?
no, certainly not.
Then?
Certainly not. But this is at variance. Your lordship,
Your document may not be proper.
Yes, that is the thing.
maybe.
Yes, that is the thing.
Maybe.
Because this is obviously a forged
Maybe.
document. It's
Hey.
obvious.
Maybe.
Forged.
Obvious. Ours is the genuine document.
It has come from the state. It
Yes,
has to be
you-
taken as this is the proper document.
So it is absolutely.
Acha, deed number, its being number is 8. 8 of 1960.
8.
Being number 8, book number 1, volume number 23, pages 95 to 98 for the year 1960. পুরোটা এখানে লেখা আছে। ঠিক আছে? Has been handed over to the learned advocate for the petitioner. Stuff. The learned advocate for the petitioner shall revert with instruction. Stuff. A copy of the deed is retained with the records. Released on Tuesday.
Deep lordship.
12 তারিখ।
Petitioner.
Any instruction from the AG?
I have not received any instruction, my lord. My lord, learned advocate general was to initiate his.
Yes, Mr. Bhattacharya is there online. I can see him.
Yes, my lord. I just received a message from Mr. Dinda that he's down with viral and the learned advocate general is also not there. He was requesting me for, my lord, agreeing to his request for having it on Monday. So, my lord, maybe have it on Tuesday instead of Monday.
It will remain in the list, Mr. Bhattacharya. I cannot assure when it will be taken up. As and when
But
the time of the court will permit. See, today there is time and both councils are not here.
No,
What
my
is
lord,
the
I am here, my
instruction?
lord. We
No,
are
tell
just
me,
waiting.
did you receive any instruction from the learned AG?
My lord, I asked the learned advocate general and Mr. Dinda also. Mr. Dinda said that it is with the learned advocate general, but my lord, I am yet to hear from the learned advocate
All
general.
right.
But may it appear on Monday, my lord, then, my lord.
It will be there in the list.
My lord.
Yes, call the next one. You are supposed to make submission?
My lord, on behalf of the learned advocate general, my lord, praying for.
Oh, AG is there.
My lord.
Well, adjourned.
Item 7 to 12 is that willful defaulters matters.
Yes,
the
yes,
five
yes,
matters.
yes,
We have
yes.
completed, my lord. Ms. Fuja was.
Yes.
And led by Mr. Chaudhary, my lord, Mr. Sabyasachi Chaudhary.
Hmm.
My lord, can give me a 5 minutes pass over, my lord. Mr. Chaudhary is on the.
I do not know why I'm here. Let us.
He is leading me. I cannot stop. This is the difficulty, my lord.
Choice is yours. Call the next one.
It's
7 to 12 is gone. 13?
7 to 12.
Not today. Same, not today. Same.
17, 18, 19, 20, 21, 22, 23, 25, 26, 27, 28, 29, 30, 34, 35, 36, 37, 38, 39.
Over with the original site matters. Cannot.
My lord, he's just.
See, you cannot keep the court
Yes,
waiting.
yes,
The appellate sides
Right, and my apology,
will
my lord, for
start.
that. Sir, my lord, he is there, my lord. Kindly take up matter. I'm so sorry. I tender my apology, my lord.
Has he come?
Yes.
All right. Dehi Teledin.
My lord, in this batch of matters, the primary challenge to an action under the RBI willful defaulter circular are on 3 grounds. The first ground, which was relating to the company, which was canvassed by Mr. Mukherjee, Mr. S.N. Mukherjee, was that their answer, there is a show cause, there is an answer, there is a finding by the first committee called the identification committee, and a affirmation of that by the review committee. So it's really in the nature of a copy paste. The answer given by them were not considered. And therefore, there is no reflection of that in the order. This is the first ground. The second ground is a corollary of the first ground, that no reasons have been given. It is unsupported by reasons. And the third ground, which is more of a technical ground, that the constitution of the committee is not correct, and the challenge to the constitution is there in both the cases. And the fourth ground or rather a corollary of the third ground, is that so far as the signing of the orders are concerned, or the communication of the orders are concerned, it has not been made by any member of the committee. It has been assigned to somebody to communicate the order. Lordship would recall, I believe Mr. Moinak Bose had given this example, that can my lord's order be signed by the court officer? That example was given. Well, these are the broad grounds so far as the main case is concerned. And my lord, thereafter in the other matters, my lord, which are really the personal guarantors and the corporate guarantors and personal guarantors, my lord, additional points are factually it is different. One is saying I ceased to be a director when that was there. Another is saying I was involved in the board but only in a technical capacity. These are, my lord, factually. So, my lord, let me first show your lordship, my lord, two provisions of the circular, because, my lord, I will first try to endeavor to show your lordship from their own answer that this is a case where, my lord, I don't say it's Order 12, Rule 6, but principles of judgment on admission would have otherwise applied. My lord, in civil cases, we have Order 12, Rule 6, where we say this is the admission. Because, my lord, let us see what is the definition that will make things, my lord, more clear. Lordship just gives me a moment. Yes. My lord, kindly take I first show your lordship the show cause notice dated 9th January 2023. This is in the Manoj Toshniwal matter, which lordship will find at page 112. Item 8 then.
Yes. Yes.
Now, my lord, the grounds are at page 113. Lordship will find in paragraph 3, criteria number, under criteria number, lordship will find 2.1.3b, which is, my lord, a omnibus definition clause. Diversion of funds, unit has defaulted in meeting its payment, repayment or obligation to the lender and has not utilized finance from the lender for the specific purpose for which finance was availed, but has diverted the funds for other purposes. But these are really, and my lord, I agree, Mr. Mukherjee is right in saying these are copy paste from the circular itself. Now, my lord, kindly come to 2.2.1c. Transferring borrowed funds to subsidiaries, stroke group companies or other companies by whatever modalities. And this, my lord, lordship can take it from me. These are identical reproduction of the definition from the circular as to what constitutes willful default. In other words, if I am the borrower and I have transferred to my group company for whatever reason, that falls within the definition of willful default. And I will try to endeavor to show in their answer, they make the admission that I have transferred it to my group company, but they qualify it and saying this is a strategic investment. So, my lord, the argument was advanced. I have said it's a strategic investment. It is they admit it's my group company. They admit I have transferred it, but they say it's a strategic investment. My lord, all diversion of funds are strategic investment. It is a strategy that I am, by way of strategy, I am removing money obtained by company X to company Y.
Yes.
But when I am on a broader picture, this is the definition. This is the definition. So when I allege that you have transferred money from this company, which you availed from the bank, to your group companies and subsidiary companies, but the moment you say, yes, I have done so, then, my lord, the reason does not justify it. It falls within the definition. That is why, my lord, I first use the principle of judgment upon admission. I'll come to that. My lord, kindly see the second one. And my lord, in this, lordship will find on the right hand side, my lord, in the show cause, I have given 4 entities which I say are your group companies or your subsidiaries. My lord, they admit all 4 of them. Only dispute they raise is the first one, steel and crane, the name is incorrect. It will mean I show their reply. And my lord, all this they admit they are the group things and all group companies or associate companies. The defense is twofold. It's a strategic investment and it is reflected and shown in my balance sheet. Does the RBI circular say that if you say it in your balance sheet, you are absolved of this willful default? It doesn't. So, this is so far as 2.2.1c. Then, my lord, kindly come to page 115. Sorry. Lord, I am not placing the other details as of now. My lord, entire detail has been given. What is the principal outstanding from all the other financial institutions? It's a detailed, my lord. Show cause is giving a detailed allegation. Kindly see the next definition, 2.2.1d.
Yes.
Routing of funds through any bank other than the lender bank or members of any consortium without prior permission of the lender. Again, my lord, I show from the reply, this has been admitted. Answer is, well, I had done it, I had mentioned it, it is to your knowledge. Well, if you are, once you admit that this has been done, in my respectful submission, my lord, it is in geometry, my lord, we had learned QED. It's QED, the theorem is proved. So, my lord, it is falling within the definition. Now, you may have a reason, you may not have a reason. My lord, my first respectful submission is that once you admit that I have routed funds to another bank, whatever may be the reason, salary account, this account, that account, if these monies have been routed through other bank, this is satisfied. You can't say that it has not been satisfied. Once you admit I have sent this money to my group companies, whatever may be the reason, you can't say that this has not been done. Then, my lord, kindly see the next one, 2.2.1e. Investment in other companies by way of acquiring equities or debt instrument without approval of lenders. I shall show from the reply, again it is admitted. Now, my lord, let us straight away come to the reply, which is, my lord, dated 15th of May 2023 at page 123.
Yes.
Let kindly straight away come to page 125, paragraph 16. Well, this is where, my lord, they start dealing with it. Well, paragraph 15. Lordship will find under paragraph 15, my lord, they have paraphrased the 4 clauses and correctly. My lord, this is, lordships can take it from me. There is no dispute. These are straight from the RBI guidelines. The show cause also does that and they also do it and correctly do it. Regarding the first event of default with respect to diversion of fund for other purposes, I would like to clarify there has been no occasion of diversion of working capital funds given by the lenders. Company has utilized finance for specific purpose it was given, and there has been no diversion of funds disbursed by the lender for any other purpose. In any event, the allegations are vague and devoid of material particulars. I pause here for a moment. Lordship has seen all the allegations on the right hand side. Lord, I have identified the group companies, I have identified the amount, and I have stated that. So it can't be vague. Now, my lord, kindly come to para 17. Regarding the second event of default, that is, my lord, 2.2.1c. Lordship will find that 2.2.1c is transfer in paragraph 15, item 2, transferring borrowed funds to subsidiaries, group companies, or other corporates by whatever modalities. Regarding the second event of default, it has been alleged as per audited balance sheet, company has made, they quote, what we had given on the right hand side. Kindly see after the tabular portion, they have written allegation, and let us deal with their reply. The aforesaid allegation. Lordship has found that, the aforesaid allegation is not only baseless, but otherwise cannot be held to be an event of willful default. Now, let us see what they say. It is specifically denied company has made investment in any company named as Steel and Crane Inc. and Quota of Technology SRL. It is apparent that the committee has not gone through the detail of investment made by the company while issuing this purported show cause. However, in order to substantiate the issuance of show cause notice was in complete non-application of mine, and in any event without jurisdiction, we are mentioning details of Advanced Steel and Crane Inc. and Techno Lines SRL instead of Steel and Crane Inc. and Quota of Techno Lines SRL. So the only difference is the names are slightly incorrect. There is an advanced prefix to this, and it is Techno Lines is not Quota of Techno Lines. It is Techno Lines SRL. Quota word is not there. But quota, I believe, has come in, while dictating, somebody must have said quote. Stenographer took down as quota, and it has come in as that. But this is the only allegation. Now, next. Kindly note, there is no denial that these are not their associate companies or subsidiary companies. Second, investments are strategic in nature. So, admission number 1, these are my subsidiaries, these are my associates. Admission number 2, investments have been made. Explanation is, investments are strategic in nature, and in the similar line of activity of the company, mainly to expand business and better synergy in ordinary course of business. Other than, the Tharurish kind of language, where, something is being said in a different context, Lordship will visualize whoever removes money from company X to company B, will come up with this and say, my associates, obviously, it will be similar line of business and that. And then, third bullet, investment advances made are with full knowledge, notice and knowledge of the lenders. Lordship will not find, any written consent or any written permission which was sought for. In fact, we have said that, and in the order also records. Now, again another admission. Aforesaid investments were also made over a period of years in ordinary course of business with full notice and knowledge of the bank and other consortium members. The investments were duly disclosed in audited accounts of respective years, which were submitted to lenders, including your bank, from time to time. Further, the same were analyzed and commented upon and accepted as reasonable in the numerous process notes finalized by lead bank, which is State Bank of India, and circulated with the consortium member banks, including your bank, few of which are annexed herewith for your reference purpose. It is also a matter of record these investments were deliberated upon at numerous consortium meetings and recorded in the approved minutes of consortium meetings. You are kindly requested to refer to the minutes. I'll come to that. Insight into your past information shared by the company and discussions held in various consortium meetings. Few of those relevant minutes are attached. The year-wise movements in such identified investments are analyzed below, commencing from financial year ended 2012 till 2018. So, their own reply contains an admission that during 11-12 till 17-18, funds have been transferred from my company to my subsidiaries and group companies. I am ignoring the strategic investment part. They give the breakup. This itself, qualifies within the definition. Why do you say it's not willful default? Because, what is willful default? If the money has gone, for whatever reasons it has gone, without the prior permission of the bank, Bank doesn't have privity of contract with the other companies. So whether you are parking the money there or it is there, and that is why, my lord, I said all these movements are strategic in nature.
Yes.
Well, the second reason which they have given is after the tabulation, one of the key consortium sanction terms with regard to advances or investments in group company subsidiary states maximum of 20% of cash accruals as on the last balance sheet will be allowed for the purpose of investment advance guarantee to its subsidiary associates in a year. If the company decides, well, this with respect, my lord, I failed, my lord, where they have disclosed this condition so far as we are concerned. Our terms and conditions are on record, my lord. This condition is nowhere there. I'll, my lord, come to that. I'll show how this has been done. Company has made advances investment in group companies. Now kindly see, my lord, another admission. Company has made advances investment in group companies over a period of years in compliance with the stipulation allowing maximum permissible cap of 20% of cash accruals and through infusion of equity of other promoters. So, my lord, there is repeated admission that I have transferred money to my group companies. Twofold defense. First, they say it's strategic investment. Second, they say that law allows me to make an investment to the extent of 20%. In other words, if I have borrowed 100 rupees, I can, my lord, invest 20 rupees to my group companies. Let them show it from the terms of the sanction. They have not been able to show. And then, my lord, year-wise, they have given another thing. So, my lord, this is so far as 2.2.1c is concerned. So that's the, my lord, the second allegation of willful default. Now, my lord, kindly see what they say vis-a-vis the third allegation of willful default, which is 2.2.1d. Lord, they have given the details, my lord, in which year, how they have done it. Lord, 2.2.1d has been dealt with at page 132, paragraph 18. I'll come back to 131 slightly later, where, my lord, they have sort of given a list of dates of the minutes of the meeting. I'll come to that slightly later. But, my lord, I am just showing broadly. Allegation is with respect to the allegation, my lord, this is 2.2.1d. Loans were raised by company from other financial institutions or NBFCs without consent of consortium lenders and was paid without bank's approval. Allegation is baseless, even otherwise does not constitute an event of willful default under the master circular as an event of willful default. Well, 2.2.1d I shall show from the circular. This is for the following reasons. Availing loans from other financial institutions is not an event of willful default under 2.2.1c of the master circular as alleged. In any event, all loans raised from FIs or NBFCs were duly disclosed in the relevant balance sheet of the company and were discussed every year with members of the consortium in detail in order to incorporate the same in early appraisal notes. These appraisal notes were circulated every year by SBI to all consortium lenders, including IDBI Bank. The appraisal notes after recording such transactions provide that the account of the company has been found satisfactory and there has been no willful default. Hence, there is no question. So, my lord, again, what they are trying to say is that, my lord, it's a case of waiver, as if the bank being aware has waived its rights. Now, my lord, let us pause here for a moment. My lord, does the RBI circular say that if you put it in your balance sheet, you are absolved of that? In usual courts, whenever a bank gives a loan, all financial documents come to the bank. There is no dispute about it. But did you specifically point out that I have done this, this is to your knowledge, this is contrary to the terms of the sanction, please approve it? You don't do it. And, my lord, it is impossible for a bank for all the borrower's account. They are going to scrutinize the balance sheets and find out where, my lord, in a submarine kind of pleading, my lord, they have put in somewhere over there. So, my first submission is mere mentioning in balance sheet does not absolve you from that. Because, my lord, The answer is yes, you are correct. I have transferred to my group companies. So one clause complied. Second, the answer is yes, you are correct. I have routed it through another account. That answer I'll just show your lordship. Kindly see the same page. At 132. Kindly see paragraph 19. I was reading paragraph 19, just after the first part of paragraph 19, the second part. In this regard, following may be noted with respect to the alleged loans. They talk of ILNFS, IFCI, very important, clause B. In the appraisal note for 15-16, it has been specifically indicated loan availed by the company from IFCI was for shoring of NWC and investment in MB. IDBI was a part of consortium and as such not only had knowledge but had consented and approved such transactions. Consent and approval is vis-a-vis I am initiating the willful defaulter action. They'll have to show that I have consented. There is a written document. They have taken prior permission. The entire defense is because you are part of the consortium where the balance sheets are disclosed, so whatever we have done, even if it is in compliance with 2.2.1c, 2.2.1d, I have put it in my balance sheet. I don't have to tell you anything further. This with respect, is not falling within the parameters of circular. That is why, the circular is saying by any means whatsoever. So if you are pleading waiver, the entire defense is waiver, that I have committed the mistake or I have committed the default, but you have waived my default. That is their case. Then, page 134, para 20. This is what, was placed and, lot of emphasis was strategic investment. Now, kindly see, one admission is over here at page 134, just the para above para 20. It is also pertinent to note that IDBI Bank became part of consortium only from financial year 14-15 and part of alleged loans taken from the other banks. Some banks have been mentioned and car loans were taken before IDBI became a member of consortium. In any event, all such loans have been mentioned in relevant balance sheets of respective years. So, admission is that I become part of the consortium later. But that doesn't give them the license to use the money and do that because you had done it earlier. Where is the assumption? If it falls within the parameters of my sanction, you are justified. If it doesn't, you can't say implied knowledge. And kindly see the reasoning. Furthermore, the investment in MB has been made by way of availing loan from IFCI, which is not a part of consortium. The investment is also reflected in the audited financials of the company. Now, how do I segregate? Or is it at all possible legally to segregate? This money is coming from this bank and this money is coming from this bank until and unless they can show that IFCI terms were to make investment in another company. That is not their case. So, today, whenever a bank will say, I'll say, no, this 100 rupees I have paid from his pocket or from this bank, and this 100 rupees I have paid from that bank. But the moment I put it in my bank or in my till, it is the identity merges. Then, they are talking that in one MOM it was mentioned that investment in MB was made through funds raised from IFCI loan. And they give details of that. I am not going into the detail as of now. I'll come to how it has been dealt with. Then, para 21, allegation, the next ground. The sundry debtors figure submitted by the company for availing DP in their cash credit account showed a drastic decrease during CIR process. The RP appraised that only 1% of sundry debtors were realizable. Sundry debtor amount shown was mainly of the jobs performed by subcontractors of EMC, for which payment were directly made to subcontractors by the beneficiary. As such, the company directors, promoters as involved in submitting bogus sundry debtors figure to avail full DP of cash credit account sanctioned by the bank. CEIB report dated so-and-so stated Central Excise Department, Kolkata had filed a report stating submission of bogus filing by company during 2018. I specifically deny the allegations which are baseless. Now, kindly see what they say thereafter. Company had regularly submitted its monthly DP statement, including list of debtors, and there was no adverse remarks or notice on the same from any of the consortium lenders. Well, they are not saying, other than the omnibus denial, they are not saying that these are incorrect. They are saying what these are correct, but I have regularly submitted the returns. So, this is a camouflage of the reality, in a language to portray that as if, you know everything. Then, the next bullet. Company has adhered to all financial discipline and submitted all relevant compliance-related documents to bank for monitoring and ensuring end use of funds. All these periodical statements are discussed at various levels, and there have been no major discrepancy observed. And then, they give a list of discussions of their performance when these certificates have been issued. But kindly see what is the primary allegation. EMC Limited and CEIB report and all this. They do not say these are incorrect. So, on their own showing, Lordship will find that all the allegations in the show cause have been in effect admitted, but then they have tried to give in a reason for that. And primarily the reason is that yes, I have done it, but the bank had implied knowledge. But my submissions are twofold. First is, moment you admit the act has been done, the definition is complied and the bank cannot be said to be wrong. My second submission is, if you are making out a case for waiver, in law, the first thing we learn is that you must be very careful while pleading waiver, because moment you plead waiver, you are admitting that this right is there or the wrong has been done. I know that I have done the wrong, but you have waived the wrong. That is, in effect, what is. When I say wrong, I mean non-compliance of or falling within the definition of circular. So, once they say that I have done it, but you know it, so, the default is admitted. So, the only limited case which the petitioner may have is whether they inform it specifically, and law is also well settled that for waiver, it has to be specific. You implied cases of waiver also, it should be parameteria with that. All right, I have informed you repeatedly for 3 months. Next 2 months, letters are missing. Implied waiver maybe. Not a single letter. So, this is what is there in their reply. Now, let us see what the identification committee in its order of 11th January has noted. Page 510, it starts. The communication is on 15th of January, which is at 508, enclosing the order. I'll come to the letter later, my lord. 510 is the order, which will be in volume 4 perhaps. Yes. The background has been recorded. Now, Lordship will straight away come to page 516. Towards the bottom of that page, brief summary of submissions made by Sri Manoj Toshniwal, the other names. Lordship will find in bullet, the broad points have been highlighted. The allegation of diversion of working funds were vague. That's the first. Second, investments were strategic in nature and were similar in line of business activity. But the investments have been made. There is no dispute. Investments were made with full notice and knowledge. Then, my lord, next is maximum cap of 20%. Then Lordship will find loan raised from NB were duly disclosed in the balance sheets. My lord, second last bullet, which is in the nature of a tick. HDFC account was opened in the year 2005 prior to having any credit arrangement with the consortium lenders. My lord, if you have a prior account, I have an old account. And my lord, to evade detection, I again resurrect the old account and I divert funds in that. Does it make any difference that if I have an old account? While taking loan, when you are saying I will not route it through any other account, does it not cover the old account as well? In my respectful submission, my lord, it has to be in the affirmative. So, my lord, these submissions are noted. Then, my lord, kindly see at 507. DG examined the factual aspect of written submissions made and submitted as under. A related transaction between a parent and its subsidiaries, associates, joint ventures shall be made only on terms equivalent to those that prevail at arm's length transactions, and as such terms shall be substantiated. Proper disclosure of related party transaction between a parent and its subsidiary associates may be required as per applicable accounting standard to enable users of financial statements to form a view about the effects of related party relationships on an entity. The borrower accepted in their reply, this is very important. The borrowers accepted in their reply to show cause notice that investments made in subsidiaries and group companies or other corporate were duly disclosed in audited financial statements for the relevant financial years and were brought to the knowledge of lenders. Merely intimating the financing banks about such related party transaction may not absolve the company or directors from their liability to adhere to accounting standards. The same is in violation of the terms of the sanction. With respect to argument, my lord, related party transaction in Companies Act, my lord, in the balance sheet, my lord, related party transactions as a matter of course, but it is there. You have to mention. How will the bank know that the bank's money will go in over there? Lord, Companies Act requires, and my lord, accounting standards required that you have to give the financials of your subsidiaries in your balance sheet. Companies Act provision is there. So, my lord, merely mentioning that I have so and so subsidiary, does it make a difference? Or I have had transactions with my subsidiaries for X amount. That is, my lord, in law, it's a compulsion. They are not doing any favor. But my lord, how will the bank know that the money borrowed from the bank has gone to a subsidiary company and that has not come back? Until and unless you say that. Well, the next bullet. With respect to the argument that advances in group companies were within the maximum cap of 20% as per sanction term, it may be mentioned that no such terms of sanction was stipulated by the bank in its sanction letter. Well, this is what I was telling your lordship. This is what the presenting officer said, and these factual aspects have not been disputed even here. Well, not a single letter has been shown this 20% cap. Where are they getting it? It has to emanate from me because I am the one who's been out of pocket. As per sanction term, company shall maintain arm's length distance from the group companies. Any capital contribution made by the company in its group companies shall be with prior permission of IDBI Bank. Well, this has been quoted over here. However, no prior written permission for investment in group companies has been submitted. Regarding the discussion held in various consortium meetings with respect to advances or investment in group companies or subsidiaries, it may be mentioned that company directors had assured in one such consortium meetings, joint land meeting dated so and so, to take necessary steps to plow back such advances to the parent company. In fact, my lord, this issue was triggered, my lord, in that, and that minutes have been referred to. That whatever I have given, I will plow it back over there. My lord, we have given, and my lord, it's not that the reference is incorrect or there is no such meeting. But kindly visualize it otherwise. A lender is lending money for the activity of a particular company. Now, it may be that the activity of that company may involve one or more of its subsidiaries. But then, if that money is being routed through the other companies, either I am having knowledge, you are taking, well, part of this 20%, 30%, whatever, I am going to give it to that. That is why, Millard, the question is of arm's length transaction. Otherwise, Millard, what will happen? The subsidiaries can also come and take it from the bank directly. So I know exactly. If, my lord, out of 100 rupees, 20 rupees goes to the subsidiary, what prevents that subsidiary, my lord, from coming directly to the bank and said, I need 20 rupees to give it to this company, to make manufactured products and give it to this company. But the subsidiary doesn't have the credentials, so subsidiary will not have it. Now, the money gets routed, it gets routed to the subsidiary defaults. Firstly, I don't have privity with the subsidiary, and subsidiary without having credentials, no assets, it will not be recovered. And Millard, we camouflage it and give the name strategic investment. Millard, I come back to that. Millard, am I detaining your lordship, Millard? I believe lordship has other matters. I can come back, Millard, whenever.
Very well. Please come. Learned counsel representing the respondents commences arguments but does not conclude the same. When?
But any day next week other than Tuesday, Millard. I have some difficulty on next Thursday or Friday if it commences, your lordship, Millard.
Friday is a holiday.
I'm
We'll
sorry.
be
Thursday,
celebrating
Millard.
Independence.
Thursday, yes, ma'am.
Thursday.
14th.
Just came in. Bishpati.
Willful.
না না আমি ঠিক আসবো, তুমি টেনশন করবে না, আমি ম্যাটারে থাকলে ঠিক আসবো, তাহলে খবর পাঠিয়ে দেবো। বুঝতে পারিনি আগে ম্যাটার গুলো এত তাড়াতাড়ি হয়ে যায়।
এটা ওই the matters, isn't it?
Yes, yes, Millard, all the matters.
সবগুলোই একসাথে
7 to 12.
Yes. উইথ করে যেরকম আগের বার কি করছিল Your Lordship.
But 7, 30 with the 8.
Your Lordship, may I permitted to be mentioned regarding item number 90, Your Lordship, there is extreme urgency. It has been wrongly filed before Your Lordship before. Item number 90. Kindly release this.
item number
90.
90.
90. Public Premises Unauthorized Occupants Act. And it has been wrongly filed before Your Lordship. Kindly
90 released.
Much.
Appearing for the I am for the oil company 227, my lord.
Further, Lordship may recall that I had mentioned this matter yesterday. Lordship was kind enough to give me leave, my lord. My lord, this action is against the drastic steps taken by the oil company against a dealer. And my lord, it has been done in such a pre-planned manner that overnight the entire position was taken by ransacking the entire unit and immediately handed over to somebody else. Now, my lord, I tell you, Lordship, this unit is being run for the law from 1960s. Initially, it was, my lord, under the Howrah Motors, and thereafter, my lord, by virtue of this Indian Oil Company came, my lord, it has come before them. My lord, and for so many years, there was, my lord, no problem whatsoever, no complaint of whatsoever nature. The problem started here. Now, my lord, if your lordships, in order to shortcut the matter, take your lordships to the show cause notice was given to me.
My lord, before my learned friend continues, my lord, there is a issue of maintainability of the writ petition.
I will satisfy. Don't worry, I will satisfy.
Let me hear what the maintainability is. What is the maintainability?
There are twofold ground. In the MDG, they have relied on, which is annexed with the writ petition, my lord. These are guidelines.
All right, guidelines.
Guidelines, my lord. That starts at, my lord, page 62. If lordship comes to page 112.
All right.
Lord, he has come up challenging the termination and cancellation of his dealership. My lord, 112.2, my lord, is the statutory appeal provided for in the, my lord, in-house appeal provided for, where the executive director will hear out him.
SC/ST dealership
He is not a SC/ST. He is not a scheduled caste. But apart from scheduled caste also, this is except SC/ST, the appellate authority will be ED.
All right.
In other case, my lord, it's the director marketing, my lord. And my lord, lordship will also see, my lord, the
what is this?
agreement.
This is a part of the agreement or what?
This the entire agreement is guided by this MDG, my lord. For all oil companies, my lord. This is the general MDG which is followed by all the oil companies. And number 2, my lord, is the DPSL agreement, the agreement signed between the oil company, starting at page 132 between the oil company and my learned friend's client. Lordship will kindly come to page 141.
Yes.
Clause number 19.
Yes.
Well, any dispute or difference whatsoever arising out or in connection with the agreement, including any question regarding existence, validity, construction, interpretation, application, meaning, scope, operation, or effect of this contract or termination thereof, shall be referred to finally resolved through arbitration as per procedure mentioned below, and thereafter the arbitration procedure is there. This is number 2. And my lord, I say, my lord, there has been no violation of any fundamental rights of the petitioner. Show cause notice was given. They have answered that. Hearing took place on a number of dates. After opportunity of hearing being given, my lord, termination order was passed. So availability of 2 alternative forums are there. Lordship will take into note.
All right. Yes.
Lord, I am aware of this alternative remedy contained in this agreement. My lord, kindly see the conduct of the oil company. The show, my lord, only 4 dates, my lord, kindly take a note. My lord, the show cause notice was issued, my lord, at page 198, your lords will find the date of that show cause notice is, I give your lordship the date, 198, 4th October 2024. I had given my reply.
4th October.
4th October 2024.
I see 21st of October. We have issued show cause notice. All right, 4th October.
Yes, forwarded 199. Yes, forwarding letter at page 199.
Yes.
4th October. And I had given the reply to the show cause notice, my lord, is at page 204. On 29th October 2024.
Yes.
My lord, the hearing had taken place on 21st January 2025.
All right.
The termination, my lord, according to the rule, they have to communicate me the decision within 45 days from the date of this reply. My lord, this was communicated to us, my lord, on 4th August, sent by mail on dated 4th August 2025. So this is long after that period. 4th August 2025, which is at page 235 of your lordship's brief. And then the following morning, and it was given, my lord, at 11 o'clock at night. I have seen it at 11 o'clock at night. Immediately, I had replied to them that kindly don't do anything. Let me take the advice from my lawyer. And the following morning, on 5th, my lord, they came, they had taken forcible possession by breaking open the lock, and my lord, immediately they had given this dealership to the private respondent on ad hoc basis. So where do I get the chance to go to the appeal court?
269.
My lord is aware of the provision that alternative remedy is no bar. If the court finds that there is irregularity, the court can, my lord, exercise its discretion and entertain the writ petition.
But right now you have already been dispossessed.
No, my lord, I have come today, my lord, not to give any effect to the ad hoc dealership. My lord, kindly sees if the third party interest is created.
It has already been
No,
created.
it is not created.
I'm
I am coming to that, please. My lord, kindly sees the appointment. My lord, kindly come to page 246.
269.
269. Sorry, 269.
Last
Yes.
My lord, I knew
269. 269.
269. 269. Last two paragraphs, my lord, kindly sees.
Yes.
Safe custody.
Safe custody of UG tank stocks, etc., belonging are handed over to Messrs. Anand Narayan Singh, representative dealer of Messrs. Otulaland Service Station, on the day of Panchanama. Panchanama was read out to Panchas in vernacular. So therefore, my lord, they came with a predetermined mind that it will be given to somebody. Otherwise, he could not have been there on the spot. And next paragraph. Henceforth, Srimati Indu Singh, the DPSL signatory of Messrs. Otulaland Service Station, will be responsible for all operations at the outlet, operating under the name and style of so and so, so and so. So therefore, my lord, I have not been given any opportunity. I have
Opportunity for what?
of testing the decision
Before
of
the
the
appeal.
authority
All right.
before the appellate authority.
All right. Show me that this is ad hoc.
Ad hoc. They are saying.
Where is it?
Third line.
Otulaland Service Station ad hoc.
Yes, my lord, in the
Otulaland
last
Service
but
Station
not
ad hoc.
Otulaland Station ad hoc.
Will be just
Dealer of Messrs. Otulaland Service Station ad hoc.
All right.
So therefore, it is not in permanent in nature, and it is in my land.
No, I am the owner.
I am the owner of the property.
That is not correct.
Yes, I
I have
This is a company leasehold property taken from a lessor. Maybe,
Proceedings
but
have
he is not the
started.
owner. He is not the lessor.
No, I am the owner.
He has
entire infrastructure by the oil company.
My lord,
Yes,
kindly consider, lordship is not going into the land dispute today before in this court.
Yes.
Only I am submitting from the record that a property belonging to all of us, it has been divided between us, but the entire land,
Us means who?
my and my other brother, sister,
All right.
Howrah Motor Company.
All right.
So it is a
And the private respondent is not one of the
no.
co-sharers or
It is completely different
third party.
Well, kindly appreciate how could they come on that the following day morning and take possession and expertise possession by ransacking everything, breaking open the law.
Was it? Is it a petrol pump or what?
Petrol pump.
And was it functional?
It was.
Functioning
It was. It has
That's why.
because, my lord, they came. They.
What was the reason for?
Suspended the operation, and thereafter, because immediately the show cause notice is given, my lord, the operation is suspended. Operation was suspended. I was under suspension, but it was my bread and butter. It was my bread and butter. But today they cannot take such drastic step, throwing me out and bringing somebody in my place and allowing to. My lord, otherwise, my lord, kindly consider that where do I go and what I will get relief.
All right. What the court is proposing.
My lord, just two things before your lordship. speaks out, my lord, with respect, my lord. My lord, first of all, my lord, his pump was in a suspended situation.
Yes, I know.
Number one. Number two, allegations are so grave. My lord, about 1,13,000 liters of petroleum was purchased from open market.
That is a matter of dispute.
No, that is the finding.
All right.
And they have signed. There are documents to show that they have signed saying that it has been purchased from open market.
All
Not
right.
1 liter or 10 liter or 100. 1,13,000.
Show me the appellate authority over here.
My lord.
The appellate authority, as per your agreement,
Yes.
as per the agreement, your guidelines.
Yes, my lord.
The appellate authority
Lordship will
is
kindly come to page. Appellate authority as per the guidelines.
112.
My lord, 112, my lord.
Yes. ED.
Appellate proceeding starts at 111, my lord, 8.9.
Yes.
My lord, 8.9 is the appellate proceeding. 112 is the appellate authority.
8.9. Who is the authority? The
My lord,
detail.
executive director, my lord.
Executive director is the party or not? No.
Executive director, no, my lord.
Not a
I
party.
have not made him.
Very well. What the court is proposing is you prefer appeal because that is what the remedy mentioned in your agreement.
Yes, madam.
And since it has been given out on ad hoc basis, this ad hoc will continue, right will not accrue. Let hearing be given to you and the authority will decide in a time-bound manner. Is any time mentioned in your agreement within which the appeal? Nothing. No time.
Appeal will be disposed of preferably just the point before that.
90 days from the
90
date of
days
filing.
from the date of filing of the appeal.
Right.
Let them file within the time. Well, we'll give him a hearing and dispose of.
Please come.
My lord, may I just only add one thing?
Yes.
Only one thing. My lord, I will definitely go to the appeal court. My lord, under the agreement, I have to go. I have come before your lordship because I did not get opportunity. Secondly, my lord, the ad hoc basis, the person who is there, my lord, if he goes on running this pump, my lord, tomorrow he will come and he may ask that some right has been accrued in my favor and I have been running. Please. I have been running this for such a long time. Lordship knows that a lot of things may happen. But only request if I can make to your lordship. My lord, kindly for the time being, ask not to do anything till this disposal of the appeal. Lordship make the time-bound program before the appellate authority.
No, the agreement itself binds. There is a binding. 90 days is
This
the
is not an agreement.
Ad hoc will not be made.
Appeal is an agreement.
appeal. Yes.
Not an agreement. সবাই মিলে বললাম
Ad hoc had to be done essential commodity.
Yes.
essential commodity.
But then it was under suspension, so the commodity was not being,
Absolutely.
That is right.
delivered
Before
from that
termination,
place.
my lord, we couldn't have removed
So
it.
if it can be
That
suspended,
opportunity was given.
if it can be suspended for another 1 month, nothing will happen.
My lord, it's already running, my lord.
No, he cannot run.
My lord,
One night.
there are two difficulties.
No, but then he says he is not going to claim any equity and it's only an ad hoc basis.
If
Kindly record that.
my lord, even we agree to that.
Ad hoc basis, it has been given to me.
Oh, you already have a petrol pump?
That's the reason it has been given to me.
Because he has the infrastructure.
Yes, I have infrastructure.
Throughout India.
And are you also a contender to this?
Share agreement.
Not interested.
Yes.
You will possibly put it up in auction once again? In case.
We'll advertise it, my lord,
Advertise
for a
and
regular
then-
appointment.
Yes.
That's the system. He will not get it directly.
Is no scope of getting
No,
it directly.
never.
And my lord, this appeal provision,
Person holds the license, he cannot apply for it.
my lord,
For another one.
the appeal
One
provision which my learned friend has shown, this is not the part of the agreement. This is
With the guidelines.
guideline.
Yes.
This is the guideline. And it is, I am not bound
The
by that.
petitioner
Agreement
was running a petrol pump. Stop. Upon noticing certain irregularities, the oil company issued a show cause notice and thereafter afforded an opportunity of hearing to the petitioner. An order of termination was passed on termination term is 235.
তোরা বলিস না আমি এগুলো বুঝি না গাইডলাইনটাও কিন্তু তো বলা নেই রং বাই দি গাইডলাইন
On 30th July 2025. The petitioner alleges that overnight the oil company took forcible possession of the articles which were there inside the petrol pump, and the articles have been handed over to the private respondent by way of an ad hoc arrangement. Stop. The arrangement on 5th August 2025. Stop. Paragraph. Specific submission of the petitioner is that after the reply was after receiving the reply to the show cause, the oil company was supposed to communicate its decision within a period of 45 days. Stop. The order of termination was passed long after the expiry of the aforesaid stipulated period. Stop. Immediately after the agreement stood terminated, the manner in which forcible possession was taken, the petitioner did not have any time to prefer appeal against the same. Stop. Paragraph.
Now, one more submission, my lord, kindly add that the guideline which contains the provision of appeal, my lord, is not the part of the agreement, and these guidelines in any event is not binding on me. Well, that is all. There is a number.
Why will it not be binding? It is the marketing discipline guidelines. You are running a petrol pump.
Kindly sees that guideline. At the top of that guideline, Lordship will find the name of the 3 oil companies.
Yes.
It is only between them. It is these guidelines for them. It is not the part of the agreement. This is not the part of the agreement, my lord.
Binding upon all the.
No, where? You kindly show that it is binding on me. This guideline is for them to follow, my lord.
Achha. It has been submitted that the marketing discipline guidelines which have been framed
these 3 companies
is not binding upon the dealer, that is the petitioner.
Yes.
Stop. The learned advocate representing the oil company refers to the said guidelines. Stop. It appears therefrom that the guidelines have been set up for
they are wrong. 8.3 apply for it. They are wrong. It is they will prefer appeal.
for maintaining the discipline in the operation of the retail network and to provide high customer service standards. Stop. The guidelines clearly mentions that the same will be applicable for the oil marketing companies and also for their dealer network.
No.
Stop. Paragraph. The oil companies do follow the guidelines. Stop. Next. As per the guidelines,
whatever it is,
now the guidelines lays down the action that may be taken by the authority and the appellate provisions. Stop. The 8.9 of the guidelines mention that in case of orders in critical irregularities, the dealer will have the right to appeal within a period of 30 days from the date of receipt of the order before the appropriate authority, who will be empowered to decide the matter, and the appeal shall be disposed of preferably within 90 days from the date of filing the appeal in the office of the appellate authority. Step. Paragraph. The guidelines further lays down that for all appeals in case of critical irregularities, the appellate authority will be the ED. ED is, you said? Executive Director, within bracket retail, in the headquarters, or any other executive director level officer at the headquarter nominated by the company. Stop. Next. There is a specific agreement entered in between the oil company and the petitioner. Annexed to the writ petition. Stop. The same was executed on 19th April 2022. Stop. The agreement mentions that any disputes or differences whatsoever arising out of or in connection with the agreement, including any question of termination thereof, shall be referred to and finally resolved through arbitration as per the procedure mentioned. Stop. Paragraph. The court very well appreciates the urgency and emergency for which the petitioner has approached the writ court for relief. Stop. Admittedly, the business of the petitioner stood suspended
Terminated.
upon issuance of the show cause notice. In August 2024, stop. The petitioner was out of business since that point of time. Stop. The agreement stood terminated on 30th July 2025.
Communicated on 4th August.
And the same was communicated to the petitioner on 4th August 2024. 25. Stop. The petitioner hardly had a time to approach the appellate authority. Stop. Paragraph. As the articles which were lying in the petrol pump of the petitioner has been handed over to the nearby petrol pump dealer, that is the private respondent herein, by way of a panchnama on ad hoc basis, accordingly, the private respondent is who is the ad hoc who is the nearby petrol pump holding the articles of the petitioner on ad hoc basis is directed to act in terms of the panchnama. Stop. Leave is granted to the petitioner to not leave. It will be open for the petitioner to approach the appellate forum or to avail the remedy of arbitration as mentioned in the agreement. যেখানে বললাম একটু পড়ুন ঠিক এই লাইনটা সেন্টেন্সটা শুরু করুন না ঠিক এইখানটা it will be open for the petitioner to approach the appellate forum in terms of the marketing guidelines or to avail the remedy of arbitration as provided in the agreement.
Either of two. Either of two, my lord. Both I cannot take, my lord.
Since you have an agreement, you
No,
can
my
avail
lord,
arbitration.
kindly appreciate, yes. The both remedies are there.
Yes,
So, my lord,
choice is yours.
so that is why I am saying, my lord, either of my lord, kindly.
I have given that
That is
choice.
what exactly
That is
I
there in the order.
Yes. And in the event the petitioner approaches the appellate authority as per the marketing discipline guidelines, comma, the appellate authority shall take steps in the matter within the time period stipulated in the guidelines. Stop. The learned advocate representing the private respondent has clearly disclosed that the authority does not seek any right and or equity on the articles held by the said authority on ad hoc basis. Stop. The private respondent is already running a petrol pump and is not a contender to the pump of the petitioner. Stop.
And he will not claim any equity, my lord?
Yes, he will not claim any. I have recorded that he will not claim any equity. The writ petition stands disposed of.
My lord, one more thing, my lord. My lord, one more thing. The petitioner will be at liberty to take the assistance of an advocate.
I do not know.
But there is no bar.
There is no bar.
There is no
If
bar.
there is no bar, then why do you want the court to enter? The other side will then say, why has the court mentioned this?
No,
So it's
no,
better.
I don't mind if they also take the assistance of any lawyer.
They may not mind, they may mind.
No, I'm saying, but I can take it so that it cannot be said by the authority.
Take a chance in case they refuse.
Yes.
You know what is to be done.
Yes.
Get
বলবার দরকার কি আছে? এটা তো your right.
Yes.
This is that matter where Mr. Bandyopadhyay was supposed to submit a report.
Yes, my lord. I am appearing led by Mr. Bandyopadhyay, my lord.
My lord, we are the complainant in a case, my lord. My lord, the prayers we have made is a very, well, it's a very simple issue before your lordship, my lord, very short issue, in fact, subject to your lordship's approval. My lord, we want, my lord, the transfer of investigation from that particular police station to the Lal Bazar or any other, my lord, specialized agency, maybe, my lord, CID. My lord, the reason being, I tell you, lordship, my lord, just give me, my lord, 1 minute.
Lord,
Let me,
kindly
my
have
lord,
a look
paraphrase
to
what
page number 3, my lord. Kindly have a look to page number 3.
My lord, my father was a director of a company, my lord, which ran, my lord, Repose Clinic, the Repose Nursing Home, which runs, in fact, even till now it runs. My father passed away, my lord, in 2015. My father had, my lord, 5,000 share of that company, equity shares. Now, my lord, those shares were with the other directors, my lord, which they held in trust. In 2022, I got to know those shares were shown to have been transferred to one accused by another director. It was uploaded, my lord, by in the website of the company in 2022 because my father passed away in 2015. Now, my lord, in 2015, the deed of gift, it was transferred by way of a gift, gift deed, my lord. The signature thereof, my lord, was a forged. The signature on the form was forged. We filed, my lord, a 156(3) application before the learned magistrate. Now, my lord, when before the learned magistrate, we filed that application, my lord, learned magistrate, your lordship knows, my lord, in terms of Priyanka Srivastava's judgment, my lord, calls for a report in order to just verify the veracity of the allegation. Now, my lord, surprisingly, a report was filed by the police at that stage declaring the case to be civil in nature. Well, we filed our objection. We put in that. Learned magistrate, despite that objection, my lord, repealed the contention of the police and directed for investigation. So my 156(3) was allowed by the same police station, my lord, by same officer in charge. No matter what they did, my lord, now they added the charges under 468, my lord, forgery for cheating,
420, the charge of cheating, my lord, is conspicuously absent in the FIR. Nor, my lord, 409. Now, my lord, your lordship knows, my lord, 406 is general criminal breach of trust. Now, if it is done by a public servant or an agent, my lord, some categories, then that will be 409, where, my lord, the punishment is higher. What they did, my lord, they added 408, which conceptualizes, my lord, criminal breach of trust by a servant or a carrier. No, my lord, we filed an application before the learned magistrate that appropriate charges were not added. My lord, in fact, subject to correction by your lordship, London magistrate expressed his helplessness that look, the charges are to be added by the investigating officer, but I'm passing an order and it will be communicated to the investigating officer. That was a petition will be communicated to the officer. This is something unusual, but not, my lord, happens as a run of the mill cases by the London magistrates. No, my lord, if the proceeding continues like this, my lord, so the result is a fait accompli, my lord. Which is why, my lord, my prayer before this honorable court is only for transfer of investigation from that particular police station and to be given to Lal Bazar or CID. I don't pray nothing of, my lord, CBI or anything of that sort. This is not a case for CBI, my lord. So it's only, my lord, to a specialized agency. And if it can be, my lord, if...
What is so special over here?
What
is the requirement? The sections I can understand.
My lord.
But then what is the requirement of appointing a specialized agency?
My lord, the issue is that, my lord, it's that flogging a dead horse, in fact, what we are doing. The same investigating, police station as such, said that this is civil in nature. Now, my lord, your lordship knows, my lord, that happened in preliminary inquiry, which was beyond the scope. No matter what rightly pointed out by your lordship, my lord,
the investigation is under progress and the learned court below is monitoring it.
No, my lord, it's not.
Type of.
It
is pending, isn't it?
It's pending, and London
Yes.
magistrate said that I cannot do anything. He expressed his helplessness. Just see one document, my lord. My lord, page 140, 177.
There is already a civil suit pending. Documents were sought for from you. You were unable to provide the original documents. This is what is mentioned
No,
over here.
my lord, I'm deeply obliged. That's the best case I have. Thankfully, your lordship has pointed out this. My lord, the gift deed is not by me. I was ignorant, so the original is not with me. Now, police annex that gift deed with their report filed before the London magistrate. With deepest respect, my lord, how can they ask the original from the complainant? Because that will be with the accused. Kindly appreciate, my lord, if the trajectory of the investigation is like this, my lord.
It is mentioned here original. Now, what original document was sought for is not reflected over here. So the court cannot understand exactly what other documents were called for. Right? It is not necessarily the gift deed.
But, my lord, here the bone of contention
documents.
is the gift deed. Number 2 is, my lord, the original transfer, share transfer form. 91, whatever has given to me, my lord, I have complied with. Admittedly, those documents were obtained by, my lord, the police.
And I see over here it mentions about the security transfer forms being signed when the person was alive.
I'm obliged, my lord. How could he do without investigation? Kindly seize this, my lord. He's so tenacious, my lord. He's a fait accompli, my lord. It's like I allege something before he takes up the investigation, he comes to a conclusion, my lord. Now, kindly appreciate, my lord. The test is, my lord, what I've learned from your lordship, my lord, is the reasonableness of bias, my lord. It's a fait accompli investigation. Without verifying the signature from the admitted signature of my father, with deepest respect, my lord, how can an investigating officer who is not an expert within the meaning of section 45 of the Evidence Act come to a conclusion to that effect, my lord? If I may pose this question to myself, my lord.
So this is the information he has gathered here. This is not the final decision. This is what he
My lord, if the trajectory of the investigation is like this, my lord, kindly appreciate what will happen, my lord, when the final report will be filed. That's a fait accompli, my lord.
This is and such. During several notices were issued, no documents were produced. Non-inclusion did not pass any specific direction. Tell me one thing, what are the original documents that you seek from the petitioner? This is not mentioned.
No, this is not mentioned.
Isn't it?
Take page 179. There is a section 91 notice. But he didn't respond to it, then magistrate issued a threat that warrant will be issued against you if you do not produce this document, that is 183. Because they allege that sum of rupees 1,65,000 was given to the company.
There cannot be any
That document
warrant to a complainant, my lord, at least not in the periphery of CRPC, my lord.
Yes, 180.
She is the magistrate since they refused to answer first 91 notice at page. First notice is 29th February, page 179. Then the magistrate had to intervene and issued the second notice on page 183.
Please, not by the magistrates, by the police, subject to correction.
Yes, 91 notice by the police. This is these are the documents which were sought for. Death certificate you do not have. Salary slip of Tapan Chakraborty. Any will.
He had made in the my father got this much of salary.
You do not, page 179 you have annexed. But you have these documents.
My lord, whatever I had already given, my lord. The income tax, Kylie says 183, which my learned friend is showing. Sees the documents, my lord, asked for. From me, the complainant, when I allege forgery, my lord, any I'm sorry, my lord. I'm sorry. 183.
Yes.
But if I may place particulars of the documents, first of all, this is not by the magistrate, this is by the police.
Yes.
Any document which will be proved, the directorship of such and such, given any receipt of copy which will be proved that the alleged share had possessed by the late Tapan Chakraborty, my lord. This is there, my lord, from the document. Death certificate, salary slip, any will or document which will be, the English your lordship, pardon me, that said share will transfer to his legal heirs. It's not required, my lord.
Communicate that these are not required.
We have
we
that,
don't have.
Just give the reply.
This is done on 16th May.
The page 185, the very next page, my lord.
Replied on the 20th May, page
Yes.
185.
Right.
And they did not give any documents of giving money.
And my lord, how could my learned friend, being an accused, know, my lord, that these documents are not with the police with deepest respect, my lord? This is
getting it from the summons. 183 is
as per the documents indicated. What is page 88?
My lord, page 188, my lord. My lord, page 188 is, my lord, the compliance, my lord.
As per the documents indicated in the notice, the documents respect point and cause no question of legal heirship.
Only two. They did not give any document.
And my lord, this is my signature. These documents are not with me.
Its transfer share was.
My lord, it's very simple issue, my lord. Signature in the gift deed, the signature in the share transfer form are forged or not.
Who is investigating the case?
No.
The officer in charge. The OC himself is investigating the case.
No, my lord, it's.
There must be somebody. It has been.
If I had
Who is the officer in charge? The officer investigating the case.
Number 3 officer in charge.
Are you aware? No.
This document signed by the officer in charge Kolaya police. But who did it? I think one.
Well, it's one sub-inspector of police.
SI Rana.
Rana.
I have
Siddhartha Rana.
No.
All right.
Investigating in the.
Let the officer in charge oversee how the investigation is going on. Then they can take steps. Please come.
Only may I request one
Yes.
subject to my lord's acceptance. If it can be overseen for the timing by any higher official, my lord, because same police station, my lord, the difficulty is your lordship knows.
All right.
Any higher official, my lord.
The petitioners claim to be
In
a
the
lawyer.
same matter in which you have shown to
These
your lord.
shares were transferred in April 2015. My lord, his father died in December 2015. He was well aware that his father was holding shares. My lord, he didn't search how it was nothing. In 2022, my lord, he first make a complaint. These shares were there. Now it was transferred. This transfer was bad. The
Transferred in favor of whom? Family member or somebody else?
Somebody else, one of the directors.
All right.
Because this was one of these repos, you know, say the promoter directors are different. His father was inducted subsequently. Now, after Malad, he also resigned from the directorship. During his lifetime. They in fact filed a civil suit on the same allegations which is pending.
It has to be heard.
Now, in order to create pressure, this ploy has been kindly see the initial report of the magistrate, page
Whatever it
144.
is, an investigation is continuing, let it be continued.
In fact, I am agreeable with the second prayer.
Second prayer.
Their prayer for injunction was already refused,
Expeditious investigation.
was not granted.
If you
Prayer.
seize the
No, what is your submission? Prayer?
The prayer for interim injunction has already been not granted.
In a civil court. That is a civil forum for which the FMA is pending against. Appeal has been preferred. That is pending.
Page 29.
From the report filed by the officer in charge
And my lord, I had already had
of the Korea police station signed on 17th July 2025.
Create pressure.
It appears that
Order of the magistrate, kindly see, my lord, order of the magistrate. They have annexed it, my lord, but I don't know whether it is legible. 176.
all right.
Take 176.
It appears that in response to the complaint filed by the petitioner, Korea PS case number 41 dated 17th February 2025 under sections 120 caps B /408 /467 /468 /471 IPC have been registered against the private respondent numbers 4, 5 and 6.
One is
Stop.
company, my lord. Even he has been accused. The company has been made accused. Right. For company, my lord, IPC, the offense is involving menswear, my lord.
No, can't be.
Whatever. 4, 5, 6 is mentioned. Acha, ठीक है जी. The reports mentions that the investigation is in progress. Stop. The matter relates to now the allegation of the petitioner is fraudulent transfer of shares. Stop. The petitioner alleges that the proper sections have not been invoked. Stop. Sections with lighter punishment have been invoked. Stop. The primary reason, according to the petitioner, is to provide help to the private parties. Stop. Next. Prayer has been made to transfer the investigation to a specialized agency. Stop. Paragraph. Learned advocate representing the private respondents denies the allegations of the petitioner. Stop. Next. Upon hearing the parties and on perusal of the report of the officer in charge, it appears that the investigation is in progress. Stop. The investigation ought to be proceeded strictly in accordance with the provisions of law. Stop. To ensure that the investigation is made in the right direction and the proper sections are invoked, comma. The court directs the
409, there is no neither
Deputy Commissioner of Police,
420 and 409.
comma, South End Division,
6 once, followed.
South End East Division, Southeast Division to oversee the process of investigation and ensure that the same concludes at the earliest without any unnecessary delay.
Only thing, Malad.
Yes.
Kindly take page 176 once. Since you also have observed that proper sections, Malad, kindly say take page 176. I've got a better copy, Malad.
I can read it.
Kindly take the next page.
Yes. This is the allegation of the petitioner that the proper sections have not been.
Axiomatically, thus there is no requirement of law to obtain permission from this court for proceeding against the accused in connection with the penal offence if so disclosed from the materials collected during the probe, when indeed the domain of investigations remains prerogative with the investigator. This court
Yes.
cannot intrude.
That is the reason the court is not intruding.
Filed before the magistrate.
All
That will
right.
include this.
Very well.
They have not disclosed anything for
Ve-
420 or 409.
Very well,
Now
it
they are
will
trying
fail. It will fail if nothing is there.
to have observed that proper sections.
No, it is the allegation and the submission. The court has not. I will check it. The court has not mentioned because the court doesn't know what it is about. Why will the court put its own inputs?
Your Lordship has observed that the officer is just to see that the proper sections are added. That observation has come.
What does this mean? That you add it? I
It
said
may
proper
be-
sections.
It may.
No, then that will be improper act on the part of the police if he adds sections which are not applicable. It is as simple as this. Next. This
Because the sections
Most
have
obliged.
already been added and the investigation is going on.
I'm deeply obliged, my lord.
একটা line লিখে দিন তো, the court, one line, it is made clear that the court has not entered into the merits of any of the allegations and counter allegations of the parties, and it will be the absolute prerogative of the investigating officer to investigate the matter strictly in accordance with law.
My lord, deeply obliged. My lord, report kept in record.
Yes.
I'm deeply obliged.
My lord, can I have a copy of the report? Because now under the new act, my lord, I'm entitled to. Being the complainant, my lord.
The report, whatever is I have mentioned is there. Please circulate a copy of the report to both the parties.
Most obliged. Deeply obliged, my lord.
Administrative approval. Project approving.
And it is the absolute prerogative of the investigating officer to proceed with the investigation in accordance with law.
My lord, I am for the petitioner. In this matter, Mr. Pritam Mojumdar is appearing. Due to some personal ground, he couldn't attend the court. My lord, sir, praying for an adjournment on his behalf, my lord.
It's a matter of 2023.
My lord,
What is your instruction?
My instruction, I am appearing on behalf of the state, your lordship. I have a
Where
very,
is the Bhatpara municipality?
I don't know.
There was a direction for service of notice upon the municipality.
That have you done?
my lord, I am not briefed with this matter also, my lord.
Just see when the court is trying to get matters disposed of, and this is the. If the council is not there, somebody else could have been engaged. This is not the way how matters are moved. The matter is pending for 2 long years. These matters are mentioned. And then the council is not here. Please come. The matter was mentioned, citing urgency, alleging non-payment of the dues of the petitioners. Stop. The matter was taken up for consideration on the 4th of August 2025, and direction was passed upon the learned advocate for the petitioner to serve upon the Bhatpara municipality. Stop. Today, there is nothing to suggest that the Bhatpara municipality was served. Stop. Accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. List the matter on 12th of September. Let notice be served upon the municipality.
Grateful, your lordship.
My lord,
Lord, I
Pritam
am for the state respondent.
Yes.
My lord, 4 also I'm praying for, not this week, my lord. Because he is only appearing in item number 3, 4, and 5.
Let me see. Are you the answering respondent? Is the state
No, Lord,
answering
it is the
respondent?
all of the municipality.
This is also the
Payment
municipality.
is lying in their custody.
Same order will go down in 4 and 5.
Oblige, my lord.
6 and 7. Six and 7 is concerned.
I am appealing for petitioner.
I had a talk with the department, my lord. They have get hold of the paper. No, Nare Baba. They have get hold of the documents recently, my lord, because it has not been traced. It's of 2017, my lord. Part payment has been made. Now, balance payment, my lord, I am seeking some 7 to 8 weeks time to clear up the entire dues, my lord. That's why in the morning I had a talk with the department, my lord.
This is the fourth time.
The record is not.
What is to be done? You want your money and the court is trying hard to see that you receive your dues. Please come. Learned advocate representing the state respondents submits that the papers and documents in respect of the instant case have been traced out recently and steps are being taken to clear off the dues of the petitioner at the earliest. Stop. 8 weeks time have been sought for.
Your Lordship, I am led by Mr. Basu only. I am there.
In view of such submission, 8 weeks will take us to the vacation.
Before vacation.
That's what I have been told. But that's
What can the court do?
Your Lordship, supplementing to what Mr. Bosumulli said, the dues are of a very old period, Your Lordship. Mr. Basumulli knows it.
No, he has already mentioned.
Yes.
Acha, released on 7th of November.
7th November. Grateful, Lordship. I hope that in the meantime, my lord. Grateful.
Expected. Next.
7 is also not same prayer.
6 and 7 same.
6 and 7 same.
Grateful.
I have for the state.
My lord, I am for the petitioner. My lord, yesterday I have received their opposition affidavit in form of the report in form of an affidavit. My lord.
May I file this?
Yes, yesterday you have received.
Yesterday received their opposition. My lord.
Let me see.
But the direction to file their opposition by 25th of
Yes, what is it? Non-payment of bills. Yes, what is your stand?
My stand, my lord, the work has been done, no doubt. But I raise objection. The writ petition is not maintainable because the petitioner has not been proved that now he's holding the post of secretary. So my lord, the work order was issued in the name of Jagannath some.
Show me.
Can you come to the writ petition, madam?
Yes, please show.
Work order is
Yes, Jagannath Cooperative Contract Society.
But the petition has been filed by Ramkrishna Mandal. Nothing.
You will pay Jagannath Cooperative.
Yes.
How long will you take?
Now, my lord, work has been done.
Yes.
What happened? The scheme has not been sanctioned. The scheme was not sanctioned by the I have filed affidavit. The district magistrate says that there is no scheme sanctioned for which the tender was invited. So,
if there is an infighting between the district magistrate and the divisional forest officer, and you get the work done from a party and you do not pay.
No. Work has been done. Now, my lord, it could be done by directing the persons, my lord, I have got that instruction, my lord. So, my work has been done. We have stated that the work has been done.
Make payment.
My lord, yes, my lord, that is.
Did you go through the opposition? Where it has been mentioned that the payment has been made?
But even no representation was made by the petitioner. Can you see from the writ petition? Since 2018, no representation made by the petitioner, by that company, my lord, and only my lord advocate's letters was sent. No representation.
My lord, in this opposition, my lord,
where has
they have not stated that already they have made some payment in respect of the work, my lord. May I submit something, my
We
lord?
have not said so.
May I submit something, my lord? My lord, in district of Birbhum, my lord, in earlier occasions, few repetitions were filed by the other repetitioners claiming the same agitation, the same grievance, my lord. In those repetition, my lord, those were few of the repetitions sending to the authority concerned, and after holding inquiry hearing between the authority concerned and the petitioner, my lord, ultimately the authority found that the work was done, and in some work the part payment made by the authority concerned who issued the work order, and thereafter finally the principal secretary or the concerned authority, the district magistrate, directed the work order issuing authority to make the payment to the petitioner, and in those cases, my lord, the petitioner already received their amount, and this case also, my lord.
Please come. Affidavit in opposition filed by the district planning officer in the office of the district magistrate and collector is taken on record. It appears therefrom that there is no denial made by the authority as regards the work done by the contractor. Stuff. The opposition mentions that the agency named Joy Jagannath Cooperative Contract and Construction Society Limited was to complete the work within 60 days. But from the completion certificate, it appears that the work was completed beyond the period of 60 days. Stop. Paragraph. It further mentions that the contractor did not file the instant writ petition, but the same has been filed by its secretary.
Not the same. We are disputing the secretary. Because he is not the secretary, we have said that he is not the present secretary. He has no location to file this.
By a person claiming to be the secretary, but the locus of the said person is denied by the authority, by the respondent authority. Stop. Paragraph. It has further been mentioned that there was no administrative approval and sanction of the scheme. Stop. From the documents annexed to the writ petition, it is evident that the divisional forest officer accepted the security money from the contractor pursuant to a tender floated and issued a proper work order in favor of the contractor, and thereafter also issued a completion certificate. Accordingly, the completion certificate clearly disclosing the tender/quotation number and the work order number with the date and the sanctioned amount, comma, the authority would be duty bound to release payment. Stuff. Next, the submission of the district planning officer.
On behalf of district magistrate. On behalf of district magistrate, this has been.
District planning officer, on behalf of the district magistrate and collector, as regards non-obtaining sanction, cannot save the respondent authorities from releasing payment after a regular selection process, a regular tender process was conducted and formal work order issued in favor of the contractor. Stop. The instant writ petition is accordingly disposed of by directing the Divisional Forest Officer, Birbhum Division, to take necessary steps for releasing payment in terms of the work done by the contractor at the earliest, but positively within a period of 4 months from the date of communication of this order. Writ petition stands disposed.
I am for the applicant.
Yes.
On the last application, you should kindly see the order regarding payment of construction material. So you should kindly see the instruction, Mr. Devanshu Dinda, I think.
Where from you did you get the instruction?
Instruction there is.
The instruction is already on record. 21st of July.
Yes, madam.
Diye din fir ot. Yes.
Because of non-availability of fund, that is not paid, Stated here.
Where is Mr. Dinda? He was there online just now.
Shobhata Basu will not in the matter, This is
No,
not
Mr.
being recorded,
All right, Mr. Dinda is there. Call Mr. Dinda.
Yes.
Chilo ekটু আগে. Call Mr. Dinda. I'm passing it over. Call him. Next.
Lord, I am appearing on behalf of the petitioner. Petitioner is a government contractor and completion certificate was issued. He has raised a bill before the authority and writ petition was moved. He is also directing the authority video release the payment. There is an earlier matter was heard and a coordinate bench has passed similar order, my lord, directing the principal secretary government of West Bengal Department of Postmanchal Unnayan Affairs to release the payment. Looking at respondent number 2, page 27 of the writ petition. Similar order has been passed by the Learned Council appearing for the state, however, submits that respondent number 2, being the principal secretary, Government of West Bengal, Department of Postmanchal Union Affairs, placed the matter before the Finance Department, who is turn has asked for field report to be prepared by the respondent number 2 for ascertaining the dues to the petitioner, other contractor regarding the work done by them. WBS such and such is disposed of with a direction on respondent number 2 to complete the field verification and submit a report pursuant to the same 2 weeks from date. The report shall be placed before the Finance Department and on 13 November.
What is your submission?
Lord, according to the earlier order, my lord, the district magistrate already sent the all documents to the Pashchimanchal Unnayan Parishad, my lord. So at this regard, my lord, the next week details report will be produced.
And DMS forwarded before the principal secretary, page 32, man.
Page
32. District magistrate already an earlier matter request order seat honorable high court such as
Otherwise, your lordship
order
kindly
seat of
direct
honorable
the
payment
respondent
of
number
pending
2
scheme bill construction
for
of such and such under Bandhan Panchayat Singh, same block. Above such extent payment, you are kindly make necessary arrangement for the payment of fund such as and in respect of 34 number of scheme.
It's one number 2.
Yes, madam. A similar order has been.
And you say that the DM has forwarded to the respondent number 2.
Lots, but
has been forwarded or not? Has it been already forwarded? Please come.
Page 32, lordship. DM has already forwarded with the principal secretary.
Is it in your matter? It has been forwarded. It is in the
all the schemes.
Your
in earlier matter.
Your matter is also there in this scheme.
34 number of scheme and earlier writ petition was moved. One of the applicant Rajpal Agarwal.
Yes.
Coordinate bench has passed similar order directing the principal secretary Postmanchal Union Affairs place the matter and directing to release the payment.
It appears from the submission on made
and representation has already
issued 34 December 2024 being memo number 65/D dated 24.
Who has sent this letter? DM. To the Principal Secretary, Poschimanchal Unnayan Department. Please give the memo number in a piece of paper so that it can be recorded. In a piece of paper, it will be recorded in the order sheet.
Repeat is a memo number 905.
Acha.
It appears from the submission.
Made on behalf of the state respondents that vide memo number such and such dated such and such. The district magistrate has already forwarded a request to the principal secretary of the Poschimanchal Unnayan Department.
Being respondent number 2.
Being the respondent number 2 herein.
Yes.
Unnayan Affairs. Respondent number 2 for sanction of fund for release of payment in favor of the various schemes, including that of the petitioner. Stop paragraph. The respondent number 2 is accordingly directed to take necessary steps and ensure that the dues of the petitioner are disbursed at the earliest, but not later than 4 months from the date of communication of this order. Writ petition stands disposed.
Grateful.
আচ্ছা একটা লাইন শুধু learned advocate for the petitioner is directed to communicate directed to forward all documents of the claim to the aforesaid respondent at the time of communicating the order of the court.
And petitioner has already made a representation before the principal secretary.
All right, you forward everything.
আমি দিয়ে দিচ্ছি দাদা 905.
No, it's not your number. This is 2024 number.
আমাকে টাকা দিবি তো? এটা তুই টাকা দিবি।
11, my lord, I am for the petitioner, my lord. My lord, the dues regarding the Assembly election 2021. My lord, the additional district magistrate floated the NIT. After that, my lord, page 17, my lord, the ADM, my lord, development, my lord, floated the
page 17.
1717.
Yes.
I have already informed the DM. Citizen was asked to submit certain documents. Documents of certain disputes arising regarding documents. Can you consider the representation?
No. Consider representation. The DM will not make payment. Your information will not do. After the writ petition is over, then everything will go.
My lord, after my lord, one thing, my lord, in respect of his claim, my lord, I am for the state, my lord.
Why so many will make submission?
I have already informed the district magistrate, my lord. Instruction has not yet been received. I am praying for 1 week time, my lord.
What are you submitting?
My lord, since my lord, the claim of the my lord petitioner, my lord, according to the rule, my lord, there should be the government engineer, my lord, who will verify the documents, my lord, and my lord, he will go into the field, my lord, that whatever the work has been done by the petitioner's company, my lord, they should verify it, and if they will find that it is a legitimate one, my lord, then they will disburse it. But my lord, they have submitted the documents without the verification of the engineer, my lord. Government engineer. That is the thing, ma'am.
Then the verification part was to be done by your officer?
Right. My lord, it has been done, my lord, but he has submitted the documents because if your lordship kindly see, already some amount has been released. That means, my lord, he has submitted the documents which were legitimate and it was verified by the government engineer. But
you must be having a copy of the verification sheet.
No, my lord.
What no?
My lord,
you are verifying some work and you will not keep records. You will rely upon whatever he produces. How can you do?
No, my lord, that documents has not been produced before the authority, my lord. That is I am saying, my lord.
And your authority doesn't have a document?
No, my lord, because my lord, just now, my lord, just 1 or 2 days has been passed, my lord. The new incumbent has joined that post, my lord.
So new papers will be generated?
No, my lord, not
then
that.
Papers will be there in the office?
If they could release the, my lord, if they could.
If he comes up with a fake document, how will you distinguish it if you do not have records?
My lord, today morning, my lord, they said that, my lord, that the documents which he has given, my lord.
Sir, please tell your officer to check the file.
My lord.
You are pointing finger at the private party. Your officer will not maintain records? Is he not required to maintain records? He'll rely upon whatever the petitioner gives.
No, my lord, he has
Then?
no. That's why, my lord.
What that's why?
Documents are required, my lord.
The learned advocate representing the state respondent submits that payment could not be released in favor of the petitioner as the verification sheet by the engineer has not been forwarded. Stop. The respondent number 3 is directed to take all necessary steps to ensure that the payment of the petitioner as per entitlement is released at the earliest, but positively within a period of 16 weeks from the date of communication of this order. 16 weeks to 4 months from the date of communication of this order. Stop. If any document is wanting from the petitioners, the same shall be made known so that the petitioners can forward the same. Stop. The writ petition stands disposed of.
Regarding item number 9, Mr. Dinda is seriously ill, so he's request me to.
Mr. Dinda is ill. Mr. Dinda was just now on screen.
Viral fever, just.
But then he is not coming here. He is there on screen and he was appearing in this matter. Just you saw him just now.
I am also mentioned because now he's suffering high fever.
Very well. Not today only.
Not today. Yes.
I am for the petitioner, my lord. This matter
Yes.
But I am for the respondents.
come under the heading payment of dues because this matter is not for payment of dues. It was mentioned for upgrade motion, mentioning in the mentioning slip. It was also recorded as listed as up for upgrade motion. If your lordship pleasures, then I am ready for the matter. I will proceed.
This is not regarding payment of dues. Put it in the updated motion bundle. All right. Ready with instruction?
Lordship, just to the first time we are appearing in this matter, this is a premature writ application is filed by my learned friend.
No.
There was the previous writ they have filed regarding that order.
Make yourself ready. It will appear in the list under the heading upgraded motion. All right.
I'm ready.
Deeply appreciated.
Lordship, that one instruction may be definitely given.
No instruction. Nothing. Next.
This is my writ petition, my lord.
I'm for the station.
This is very unfortunate case of an aged senior citizen, my lord. In spite of giving my lord, the house for rented into the office of the ICDS project to 2021, my lord, they are not paying the meager amount, my lord. Page 50 is my claim, my lord, and 49 the DM also, my lord, passed an order directing the ICDS project concern, my lord, to make payment on ad hoc basis. That was also not been done.
My lord, on 24/12/2024 by a memo number, my lord, 496, I have forwarded to my superior authority, that is the respondent number 3 for fund, my lord. There is no fund in our hand, my lord. We have paid.
You are for?
My lord, I'm for the state, my lord. I'm led
The
by
higher authority is also the state. Not that the higher authority is somebody else. So you'll be representing the said person who is saying that he doesn't have funds. Right?
Kindly give some time so that fund may be released, my lord.
Who is the officer enjoying the property?
My lord, respondent number 6, my lord.
I will tell immediate removal.
Respondent number 6, my lord. Respondent number
Immediately
6,
ousted.
my lord, it's a rented house, my lord.
It will be immediately ousted.
My lord, we'll pay.
What right do you have to occupy a private property without paying rent?
My lord, we'll pay rent, my lord. We'll
When
pay
you
rent.
pay, then again you'll be put back in possession. Right now you'll be thrown out.
My lord, kindly give us some time. so
Why?
we can-
Since when is this payment not being made?
21.
21.
Yes, my lord, this is the pay. Can you see the page 50?
Any sympathy to be shown? Do you expect?
Give us at least 10 to 15 days time so that we can arrange the fund. my lord.
Next Friday, the matter of Friday is a holiday. Following Friday, the matter will be there in the list.
My lord.
In case payment is not made, you'll be out. The petitioner alleges that the outstanding house building rent. No, outstanding. No. The house building rent is outstanding since January 2021. Stop paragraph. The private property of the petitioner is being enjoyed by the Child Development Project Officer, Kaliachok-Roman 3, ICTS Project Malda. Stop. Next. The learned advocate representing the state respondent submits that rent could not be paid for want of funds. Stop paragraph. The court is of the opinion that the state cannot, under any circumstances, enjoy a private property without payment of rent for years together. Stop. Hearing of the writ petition stands adjourned till 22nd August 2025. Stop. If payment is not released in the meantime, comma, the court will be constrained to pass order of eviction.
Deputy, 22nd. I'm ready.
Item number 14, 15, more or less a similar type. Kindly takes item number 15 first, for the sake of convenience.
Yes.
Item number 15. This lady is a senior citizen, aged about 63 years. She has decorated a business, kindly straight away comes, there was an earlier round of litigation, subsequent thereto, kindly straight away comes to page number 48 of the writ petition.
Yes.
But there was a direction to communicate. Now there is a due amount of more than about rupees 6 lakhs. Precisely in this communication, it was told that they do not have funds. Communication was sent to the Panchayat the PRD department for release of funds. Now this is a claim.
What is the due that has been crystallized? Has it been mentioned?
5,94,937 plus 20,000 earnest money.
All right. That
Malad,
is 6 lakh and odd.
Yes, since 2013 this is pending. Now this is what the communication is about. Kindly sees, page number 49 comes to page number 49 once.
Yes, I have seen that.
Yes.
The petition will be paid as and when fund will be available if approved by the competent authority.
Yes,
Yes, please.
We are only in item number 14, not in 15.
Who is there in 15? Service?
The service is there,
Notice of upgradation or something? Notice of upgradation? Notice of upgradation?
Notice of
Upgraded, no?
Upgraded.
Appearing, inquire.
I'll have to inquire, then I'll just. May I come back at 2 with this?
Not at 2.
Proper with regard to 14,
14 has not been placed.
not been,
He has not placed as yet.
my lord, I am saying 15 টা আগে place করেছে।
15 টা আগে place করেছে।
14, true, but then 14 I was running. 14, my lord, identical repetition, same prayer, same thing, everything same.
With 15?
14.
14 is identical with whom? 15?
Earlier,
Oh, earlier.
That is itself annexed.
yes, I am showing that.
And the earlier writ petition, what happened to
There was
that?
a direction to communicate a reasoned order in the RTM number 15 your lordship has seen. Till date, that has not been communicated since year has passed by. I could not prefer a contempt, I prefer a writ petition.
You have given a notice for contempt, that is at page.
Yes, I have.
Where is the earlier order?
Earlier,
The earlier order is at page number 45.
45. You can go for implementation. You cannot.
No, the difficulty is the 1 year.
Yes, implementation by way of a writ petition. What will be the reasoned order? Where is the reasoned order?
Reasoned order having not passed, my lord. He has given next page, page 47.
No, bring the reasoned order, please.
My lord, nothing has been communicated. He has given notice for contempt. I don't know whether contempt.
They cannot run away from the fact that 10 lakh order is
No,
pending.
second writ petition is in any event is not maintainable.
An order is to be passed in terms of the order passed by the court. Where is that order? Please bring that order on record and the writ petition can be disposed of. Please come.
15.
The direction passed by the court on 8th July 2024 in WPA 9181 of 2024, directing the respondents to intimate the petitioner with regard to the issues raised in the writ petition by passing a reasoned order has not been communicated to till date, has not been complied with till date. Stop. Next. The time period within which you say that the time period has expired for filing a contempt.
No.
I don't see. The
1
time
year
is
has
still there.
passed, my lord.
Where? 1 year? Where from do you calculate?
Consciously.
But the order was passed on 8th July 2024.
Right.
So,
And then the contempt arises from?
From the date it comes to the knowledge.
No, sir. No, sir. You are mistaken.
Since then, it could have created ambiguity. That is the reason why.
No question of ambiguity. Absolutely no question of ambiguity. I don't say that this writ petition is not maintainable, but I say that the contempt is also maintainable.
Yes. Well, it could have been, my lord, because since there could have been an ambiguity, I prefer this.
No ambiguity. The law is very clear. There is absolute no ambiguity.
Kindly come to page 29. Affirm this petition on 28th of March 2024.
March 24?
March. So that is ওটা পরেরটা এটা ওটা আগের writ petition.
আচ্ছা
ওটা আগের writ petition.
Anyway, my lord, I am mistaken.
হ্যাঁ
Yes.
ওটা annex করা আছে তো পুরোটা.
Yes.
30th July 2025.
Within which the order was to be communicated. The reasoned order was to be communicated has expired. Stop. Learned advocate representing the state respondents.
Yes, my lord, I say that
is
it is not maintainable.
It is not maintainable.
This writ is not maintainable. Same page to page, my lord, line to line, prayer, everything is same.
For implementation of this court's order, this writ is not maintainable. Now I have to.
What is prayer? Kindly see the prayer. Kindly come to page 11. Sorry, give me a second, one. Kindly come to page 11. I can understand one is asking for implementation of.
Yes.
It's not that.
Kindly comes to prayer C.
Pursuant to the representations, you could have mentioned pursuant to the order passed by the court. This would have cured.
That is what I have pursuant to the representation that is appearing as annexed.
This is what is vague.
Everything.
Who was to pass the order?
BDO.
The block development officer.
BDO.
কি বললাম? সেটা হয়ে গেছে। Learned advocate representing the state respondents is directed to produce the order, the reasoned order, to be passed in terms of the direction passed by the court on 8th of July 2024. Release the matter on 29th of August. Service is taken on record.
Learned advocate is there, item 15, my lord, is there.
Who is there?
Item number 15, my lord, for the state, Mr. Somnath Ganguly is appearing.
Where is he?
It is engaged in court room number.
Who is assisting him?
My lord,
Who is assisting him?
my lord, Kolpita Paul, my.
Call him, call her. Somebody should be there. Bring your other side. Yes.
My lord, I appear for the respondent number 2, my lord, reserve bank.
Yes.
My lord, I am for the petitioner, my lord.
Vishnu Chaudhary is appearing for the respondent number 1.
Microphone, microphone.
Your Lordship, Mr. Jishnu Chaudhary is appearing for the respondent number 1. He is in some personal difficulty today and on Monday. I'm praying that this matter be taken up on Tuesday or any day after.
My lord, Tuesday I have difficulty, my lord, because Tuesday I'll not be, Tuesday and Wednesday I'm not there in the court, my lord.
What are you filing? The
My
exception?
reply to the opposition.
Please give.
I'm
Please give.
My lord.
What is the matter about?
My lord, it is a matter of fraud from my account, my lord. 33 lakhs odd has been fraudulently been taken from my account. I had reported to the bank, though the transaction was done through me only, but I've been duped by a wrong police officer claiming himself to be from Bombay Crime Branch, my lord. And I had reported to the bank, my lord. Your lordship had passed an order, my lord, on the last day, if your lordship sees, my lord, that they should come up with a report, my lord, as to what steps they have taken to recover that money, my lord. They have filed their opposition, my lord. At the last paragraph 7, my lord, of your lordship reads, my lord, the bank in the report shall mention.
Yes, what is there in the report?
My lord, they have not mentioned anything as to what steps they have taken.
It mentions the respondent bank, after receiving the complaint, processed a shadow credit of the alleged transaction pending investigation. Reversed. In view of the investigation, authenticated by a two-factor authentication. Detailed step up has been taken. What can be done?
My lord, it is admission on their part that right on the first day, they knew to which account this money has been transferred.
Right.
And my lord, it is a guidelines of the RBI, my lord. If I report to them, my lord, they can stop the money. They can inform the bank where the money has been transferred, so that the money cannot be taken out from there. They took no steps, my lord. And the important part in this case is, my lord, 8 lakhs of mine was fraudulently taken out, and thereafter they transferred me 25 lakhs as on account of instant loan on the same day, my lord.
Did you make the police a party?
My lord, I have made police a party, my lord. I have lodged an FIR, my lord.
Yes. What is the stage of the FIR?
Police, I went to the police station, my lord. Police did not say anything about the inquiry, my lord. Why I am here before your lordship, my lord? Now the bank wants to recover that money from me, my lord. Whereas 8 lakhs odd of my own hard-earned money has also gone along with that over and above 25 lakhs, my lord.
Please come. The reply in the form of affidavit filed by the petitioner is taken on record. Stop. Accommodation has been sought for on behalf of the learned advocate representing ICICI Bank. Stop. Released on 22nd.
Great.
Item number 15. Well, the other side is here. Item number 15.
Yes, 15.
Item number 15, I am led by Mr. Somnath Ganguly. In this matter, I'm not got any instruction, Lordship. Kindly give me some time, my lord.
Only not today. Let it remain in the list.
Lordship.
Don't call any other matter.
Give.
But I am for the petitioner. But yesterday I have mentioned the matter, and thereafter that I left the court due to my mother's illness, and my lord, thereafter my lord,
Is your other side here?
My lord, I have already informed the court. Probably in Rakhi Raksha Bandhan program, my lord.
It's going on?
Was, my lord.
It was?
Yeah.
What do I do? I pass it over yours.
My lord, may I start, my lord? He will come.
Then he will not.
He will, my lord, Mr. Mahato, both the Mahato, I have informed, my lord, Mr. Prashanto Bihari Mahato told me that he will just reach.
What is your prayer? Immediate relief that you are claiming?
My lord, what I am asking for, my lord, that is, my lord, during pendency of this, my lord, they have invoked their bank guarantee, which is of 11,89,000. And if your lordship kindly come to page 28 of the application.
Yes.
This is the email which I have received. Your lordship kindly see that with reference to the trailing mail received from such and such, we like to inform you that WBSRD has demanded for invocation of such and such rupees 11,89,000 of Messrs. Porike issued on such and in favor of the execution of such and such. They have already invoked, and bank has already, it has been deducted yesterday from my account. So at present, what I am praying before your lordship, that is my prayer before your lordship, that this 11,89,000 should be, my lord, they can fixed it at any fixed deposit or any interest generated fixed deposit. They cannot appropriate this money for their purpose.
What was this money?
So that is what the NIT bid.
Yes.
So lordship, my lord, heard the matter, my lord. We have got one, my lord, work order issued.
Yes.
The original, that was my
Subject matter of challenge relating to the
termination of that bid.
Oh, termination.
Yes, we have challenged that termination because,
at present, my lord, I am not objecting the prayer of my learned friend because, my lord, let it be
decided first by the court.
Decided.
Then why did you go for invocation
because,
of the bank guarantee?
Date was up to,
Date
that is a 8/8.
It could have been extended.
Yes, ma'am. It can be extended, but they are liquid.
In the meantime, they have invoked it.
Yes, ma'am.
And money has already been deducted.
Yes, my lord. Your lordship kindly come to page 30.
Money be fixed before the, my lord, the interest bearing account.
Your lordship kindly come to page 30. That
and
is
what is the position of the main writ petition? Is it ready for hearing?
It is ready for because they have filed that.
To get it heard before some other bench having determination. See, look at this bench. I am continuing with hearing matters and motions. So many motions.
Where shall I go?
There is
the fixed in the year.
No, irrespective of years.
That court, my lord.
No, I do not blame.
No, my lord, I am not saying anything. My lord, because, my lord, that was a division bench, and when and
as and when.
That's why this is the problem.
At least you still have a chance. Here,
my lord, we can.
Motions are over flooded.
If I am agreeing, Mr. Mahato will not be there, then the matter will be adjourned.
No, you.
Because, my lord, that is the problem. Is when it
you
will sit,
put a chain around Mr. Mahato and take him when the matter is called on.
That is not possible.
No, it's possible.
I cannot fully.
Why? Invisible chain is always there, isn't it?
Yes.
So it's not necessary you have to handcuff him. You tell him he'll be there.
Generally, my lord, I assist the court.
Yes.
Generally, I assist.
So the other Mr. Mahato is also there, at least.
Not Mr. Mahato, my lord.
More
Today
senior.
is Friday.
More senior.
Today is Friday, my lord. It is not expected that
he'll be here.
He will be here. But there are some contaminators, so he has.
Please come.
And, my lord, also, my lord, one prayer also that along with that, because I have also given, my lord, one security deposit of 36 lakhs. So, my lord, till the hearing, they cannot, my lord, fixed deposit of 36 lakhs.
Where is that 36?
36, my lord, that is in
that was initially there. That was
three of my this application.
No, this security deposit was there at the time of the execution of the agreement or contract, whatever.
Yes, ma'am.
Performance.
Performance security.
Your
Madam,
performance is bad and they have terminated the contract.
Para
Please come.
Para 3, my lord, your lordship, last line of that page.
Acha. The writ petition has been filed challenging the termination of the petitioner's contract. Stop. The writ petition is ready for hearing.
It is 108 of your lordship's original writ.
In the meantime, the respondent authorities have proceeded to invoke the bank guarantee and a sum of rupees 11 lakh
89,000.
11,89,000 has already been deducted from the on invocation of the same. Stop. Next. The learned advocate for the petitioner submits that as the issue of termination is pending consideration before the court, a direction may be passed upon the authority not to use the bank, not to utilize the money till the matter is finally decided. Stop. Prayer has also been made not to utilize the performance security deposit, which is with the authority, to the tune of rupees 36,30,000. Stop. Paragraph. Learned advocate representing the state respondents submits that the matter is ready for hearing and the same can be decided by the court. Stop. Paragraph. The matter cannot be considered for hearing immediately because of the pressure of the listed motions. Stop. It will be open for the petitioner to get the matter heard before any other honorable bench having determination. Stop. For the time being, as the issue is sub judice, the respondents are restrained from using the money as was available in the bank guarantee to the tune of rupees 11,89,000 and not to use the performance security deposit to the tune of rupees 36,30,000. Stop. The respondent authorities are directed to invest the aforesaid amount in any short-term interest-bearing account. Stop.
From date, my lord.
At the earliest.
From the date of communication.
Achha.
From the date of communication.
At the earliest. Achha. Our liberty to mention the matter. Affidavit of service is taken.
My lord, affidavit of service may be
Yes,
kept.
please.
At the earliest.
And my lord, can one may be disposed.
Can disposed.
Thank you. The law does not want to discriminate any relation, and Mr. Mahathir does not discriminate anybody.
He is always there for everybody. Yes. Did not give chance to the senior.
No. Law does not discriminate anybody, and Mr. Mahathir does not discriminate anybody.
of I cannot.
My mate is Rossi.
Yes.
My lord, I intend to file my opposition before.
Listen, the volume of your opposition is such that it is really raises concern. What have you annexed in the opposition?
The documents, because this matter relates to several incidents, Your Lordship, and various representation was forwarded to the different authorities. All the documents, chart sheets are here, Your Lordship, which is required for the hearing. Unless until if I don't bring this entire things in record,
yes,
it will be difficult for us to do the hearing, Your Lordship, for our argument's sake.
The writ petition is not so voluminous as the opposition is.
He has not given any opposition, and therefore my lord said on the other day that I shall not accept any opposition.
No. That was not. My lord said that we till date after the completion of the hearing we'll accept. My lord will accept the written notes, not about the written.
And now my learned friend is raising so many points. Only locus standi he has got in 314 case, sexual sorry, PS case number 314.
I have been added as parties long back, Your Lordship. Kindly allow me to file it, Your
But he
Lordship.
did not prefer to file any opposition for the last 3 years.
When I'm preferring it,
Last 3 years, the matter was not taken up, and you also did not choose to file the opposition. Now, when it is absolutely at the hearing stage, you
Your
come
Lordship,
up with
it
this.
was the only reason. That is the fact, Your Lordship. But the matter was dismissed. Thereafter, it was restored, so we were not able to file. Now, when it has been restored, it has come up for
And
hearing.
in which matter are you filing the opposition?
Your Lordship, in both the matters, Your Lordship. I intend to file in both the matters, Your Lordship.
How he can?
Your Lordship,
Only he has got locus standi in case number
Your Lordship,
314. while he
Your
is
Lordship,
the victim.
Your Lordship, in writ number 18030, I've already made a party. And for other two, I have filed my CRAN.
And the opposition is for all the 3 writ petitions?
No, there are 2 writ petitions, Your Lordship.
2 writ petitions.
One I have been allowed, and another
18030.
yes,
You are already a party.
And in the 15368, I have filed 2 CRAN. One is for Mamta Agarwal and one is for Shafiq Ahmed.
No.
Yes.
He cannot do it for Shafiq Ahmed because whether Shafiq Ahmed is
Already a party into
competent in manner. In case number 314, Mamta Agarwal is the victim. He has locus standi in view of section 2 of the Code of Criminal Procedure because he is a victim. How he can be added in other 2? Because he has no locus.
Because it has been added, sir, Your Lordship, it has.
Shafiq Ahmed come. Why?
Shafiq Ahmed has already been added as party, so I'm filing it on 18308.
Why?
18030, you are already a party.
Yes, Lordship.
All right, only in that matter you file your opposition. And there are 3 criminal cases.
Your Lordship, and
4 criminal cases.
if my CRAN 1 and CRAN 2 is not allowed, so I won't be able in the position to file on behalf of Mamta Agarwal, Your Lordship.
Yes.
To be disposed of first.
Then my hearing be over.
Mamta Agarwal is the victim.
Yes, in FIR number 314, Your Lordship.
Yes, only.
Yes. Mamta has been added or not?
No.
Mamta has not been added.
Oh, no.
All right, Mamta can be added.
Yes.
And her opposition will be accepted.
In that circumstances, both are added. So I'm filing on behalf of both.
In 2 different writ petitions. All right.
Leave.
Opposition gulo rakhte hobe. Yes.
Yes. Copy.
Let copy be served.
Yes,
Certainly.
আমাদের দিতে বলো
স্যার আমি দিচ্ছিলাম নিয়ে নিন।
দিয়ে দাও ভাই, যশ সাহেব বলেছি তো,
হ্যাঁ,
দিয়ে দাও।
দিয়ে দিতে শুভস্য শীঘ্র।
ওইখানে তো রাখুন না, খুলতে লাগছে না।
Travel through,
Yes.
I made receipt.
Mm-hmm.
So long I have traveled, my lord, in 3 cases belonging to sexual sorony. Now I am, my lord, traveling to the last case, Anandapur PS case number 188, which is at page 26 of Can 4. Page 26 of Can 4. 188 of 2018. Page 26 of Can 4, para 22. Page 26 of Can 4. Thank you. The FIR starts from, my lord.
Wait 1 minute.
No. Again, para.
Yes, page 26.
Para 22.
Para 22.
But I have made, this is a page 26 of para 22. Can 4. Yes. Well, I have prepared a gist, very gist of the complaint itself. Well, that it is just okay, Devin.
Yes.
Well, it is
This is
related to
Anandapur PS.
only Anandapur. Very.
Mm.
Well, the complaint was registered on 25th of June 2018.
Mm.
Well, it was the complainant claims himself a very reputed businessman, and my lord, who is also associated with various companies in the capacity of director. Now, my lord, it has been alleged in the complaint under section 420, 406, 465, 466, 467, 468, 120/34. But the charge sheet has been submitted only under sections 400, 420, 406, and 120. So what is the complaint? I tell you what is very shortly. He is a renowned businessman. The paragraph 3 speaks that he was induced by Rajesh Agarwal, Vedanta Agarwal, and the present petitioner, who were managing the day-to-day affairs of the amalgamation company along with the other directors. Now, my lord, the next paragraph, in paragraph 4, my lord, will find that he was approached by Rajesh Agarwal, who had introduced the component with the others. Others means Parag Mujumdar, Vedanta Agarwal, and Mr. Ghanaswar. Now, my lord, in para 6, this is one very important, para 6. He had invested huge sum of money to the tune of rupees 60,15,000 to Leonin Private Limited and rupees 4 lakhs to Leonin About Private Limited. The promise of entering into a development agreement. But he was the director of that company. But kindly take note, date of joining is 22nd of June 2012. But kindly take note of date of joining. Date of resignation from the company on 1st of November 2013. During this period, he had invested the entire money while he was the director of the two companies. And he had invested 65 lakhs 15,000. The company suffered a loss. Now, my lord,
His money has gone. Now, as a developer, he wants to regain the money. He wants that the money should be repaid to him. How? Not by way of civil suit, not by any way to the any complaint to the register of companies, but he wants to take the money by implicating the petitioner in a criminal case. Can the criminal court be utilized for taking the for gaining the money?
Company has not been
Company has not been made a party. Company has not been made a party. Now kindly come to the complaint itself at page 127 of Can 4.
20,
Page 127.
27 Can.
Yes.
The complaint is at 128. I have summarized the complaint to your lordship. Now, madam, kindly see the names of the accused persons. At 135. At 135. At 135. Look at the names. Rajan Agarwal, Rajesh Agarwal, Anurada Agarwal, Vedanta Agarwal, Parag Mujumdar, Anastam Das Sharma, Mrs. Arun Kumar Mohata, Mrs. Rajeshri Mohata, Mrs. Manoj Kumar Sharma. The company has not been made a party. Because the company is a juristic person. The company is not made a party. The directors cannot be made vicariously liable for that. And that is the law, settled law of the Supreme Court. My second point is, he was approached by Rajesh Agarwal. The complainant was approached by Rajesh Agarwal. The first paragraph starts with that the petitioner, the complainant was induced by this Rajesh Agarwal, Vedanta Agarwal, and Parag Mujumdar. Then he says, the complainant says, he was approached by Rajesh Agarwal, who had introduced himself with the present persons, namely Parag, Vedanta, and Ghanasam. And he had invested 65,14,000 in two companies, not to anybody, not to any personally, not to the present petitioner personally, individually. Then,
how was the money paid? By cash?
By check. I said so. I said so.
Check.
I said so. And during that time, he was the director of that company.
And the check was in the name of the company.
I said so. Page 134. Thank you. Page 134. Look at how the money has been paid to all to HDFC Bank.
And this Leonie, the complainant was also one of the directors.
Point of time.
All right.
And you see the date of appointment is 22nd of June 2012. Date of resolution admitted fact 1st of November 2013.
Yes.
Now see, my lord, at page 34, number 3, Anil Kumar Bhuteria. The check date 4th September 2012. After 22nd of June. Does you also get it? Now, my lord, can you see number 10?
Yes.
The date of check 26th of March 2013. His date of registration is 1st of November 2013.
Who is this Abcon Properties?
Well, that is one of the companies.
That is also one of them. And whose company is this?
That is the company of the complainant.
Complainant's company.
Yes. Complainant himself. Therefore, during his tenure, my lord, the company suffered a loss. And he has lodged a complaint that he was induced by Rajesh Agarwal, and he made him acquainted with Parag Mujumdar and the other two persons.
In the other cases, this Anil Bhutoria's name was not there.
No. This is a different complaint.
Yes, but why have you tagged all the complaints together?
Hoisted by them to implicate me one after another.
Yes, but
That's
then
why, my lord, I have tagged this case along with this. This is only the 4 cases which are pending against me. Other 3 cases are caused by the Honorable Supreme Court. Those are again, my lord, restored back to the Honorable Court, if not otherwise settled. Then, my lord, this case was initiated by them.
yes, but then you have filed for quashing and you have tagged all the criminal 4 cases.
We have filed 2 separate writ petitions.
2 separate writ petitions.
And during this period, my lord, there is no specific role ascribed to the present petitioner. What is the role played by them? Played by the present petitioner? My lord, inducement is not an offense. Mere inducement is not offense. But take for example, after inducement, if I take the money from you, and if I have the intention to cheat anybody, then it can be said cheating. But mere inducement is not an offense. Say, my lord, take for example, my lord, do not misunderstand me. There is a case of 420 by 376. Promised to marry, did not marry. But mere promise is not an offense. If after promise and if I do something wrong, then it's an offense. Even we accept paragraph 3 of this complaint, that I had induced the complainant to do something.
What has happened? She wants to say something.
They have watched this case just to hold me.
When my learned friend is correctly telling me that when there is mediation before the Honorable Supreme Court, and in between this case was hoisted. Now, my lord, therefore, mere inducement is not an offense. Therefore, what is the allegations against me? The charge sheet has been submitted against me under section 420 and 406 of the Indian Penal Code. If 420 goes, then 406. First entitlement, then if I misutilize the money, misappropriate the money, I have not done anything. If anything is done, that is by the company. And in your tenure from, my lord, 2012 to 2013, the company has suffered a loss. You were the director at that point of time. And therefore, you had invested money to gain from the company. You have suffered a loss. Then how it can be 420 or 420 of the Indian Penal Code, 420 or 406 of the Indian Penal Code? Now I shall take you to receive the references. Can you have a look at the last page? আলোক যশোরকে দাও ওদের একটা জাজমেন্টের এডেনারি ফার্স্ট রেফারেন্স ইজ মাই লর্ড এসকে টেক আলাগ ওটা দে না আরেকটা দে নাও দেবো আরেকটা দিচ্ছি যে
But these are reported judgments. You made a list.
I have made a list. I'm giving them so that, my lord, they are not harassed. It is very. Just like আমাকে ফেলে দিয়েছে হ্যাঁ আমাদের দে আর kindly take any paragraph 12. Paragraph 12, my lord. The short question which arises for consideration is as to whether the complaint petition, even if given face value and taken to be correct in its entirety, disclose an offence as against the appellant under section 406 of the Indian Penal Code. This is pat on the point. Section 405 defines such and such. Whoever being in any manner interested in property or with dominion over property dishonestly misappropriates. There are two parts. One is entrustment, and second part is dominion over the property. I had no entrustment. I was not interested with the money. I had no dominion over the property. And what the Supreme Court says? Paragraph 14. The appellant number 1 is the managing director of the company. Respondent number 3 was the general manager. Indisputably, the company is a juristic person. The demand drafts were issued in the name of the company. The company was not made as an accused. The dealership agreement was by and between Mrs. Aksar and the company. And there were such and such. Now, let us kindly come to paragraph 16. A criminal breach of trust has been murdered. Described by the paragraph 80. A criminal breach of trust is an offence committed by a person to whom the property is entrusted. But I can't take note of it. I was not interested. The ingenious of the offence. A person should have been entrusted with property or entrusted with domain or property. That person should reasonably misappropriate or convert to his own use that property. Reasonably use or dispute of that property or willfully suffer any other person to do so. The question of misappropriation. All manner of conversion does not arise at all because the money was not given to me. The such misappropriation, conversion, use or disposal should be violation of any direction of law prescribed, the mode in which such trust is to be discharged. As admittedly, the acts were drawn in the name of the company. Even if the appellant was his managing director, he cannot be said to have committed an offence under Section 406 of the Indian Penal Code. Only my answer is here. I am pat on the point. And therefore, my lord, charge sheet is under Section 406 and 420, 406 goes on the face of record. This is not my defense. Now, second case is P.T. Gupta. Law? I am not going to paragraph 20 to 28. It is always my last time. Paragraph 20 to 28 is the main task. But paragraph 20 is only that. Exactly on the point. Paragraph 28. I am saying what is the role of the present petitioner. No role has been ascribed to the present petitioner excepting being that he has introduced with the petitioner and he has induced, nothing more. What is the role here? We have carefully considered the abandonments of the complaint and the statements of all the witnesses recorded at the time of the filing of the complaint. There are no specific allegations against the appellants in the complaint, and none of the witnesses have alleged any role of both the appellants. So I am on this point. Simply on this point. Therefore, my lord, the entire allegations made in the complaint goes against me. The company was not a made party, I was not a.
Sir, reference টা এখানে লেখা নেই।
লেখা আছে তো।
পিটি গুপ্তা মানে রেফারেন্সটা দেন।
পিটি গুপ্তার রেফারেন্স। পুরোটা রেফারেন্স। ও লেখা নেই? না না। এই সরি আই এম অ্যাকচুয়ালি দেখ পিটি গুপ্তা ও রেফারেন্স লেখা নেই না? ওটা আমার থেকে নেই। সরি আই এম অ্যাকচুয়ালি সরি ব্রাদার। এটা হচ্ছে 2010 3 Supreme Court cases.
Supreme Court cases.
Criminal page 473.
473. Thank you, sir.
Indra Goswami. Next is my lord. Yes. Indra Goswami. But this is a three-bench judgment. Indra Goswami. Well, Indra Goswami, this is paragraph 21, 22, 42 to 46. Well, that is in the points of law I have also given you. Now, paragraph 21. We have heard the learned counsel for the parties are late. The appellants were the office bearers of a charitable organization, namely such and such. In order to protect the interest of the Sabha, cancelled the power of attorney by executing a registered cancellation deed after giving notice to the power of attorney holders. The appellants sold only that part of the land to Sunil Kumar on behalf of Sabha, for which an agreement to sell with the components had already been terminated. The respondents' earned money had been forfeited. All of this was done only after the appellants had given the respondent due notice. The veracity of the facts alleged by the appellants and the respondents can only be ascertained on the basis of evidence and documents by civil court of competent jurisdiction. The dispute in question is purely civil in nature, and respondent number 3 has already instituted civil suit in the court of a civil judge. In the facts and circumstances of this case, initiating criminal proceedings by respondents against the appellants is clearly an abuse of the process of the court. I submit that during his tenure as a director of that company, he had invested the money for his profit. If he had any grievance, he could have made complaint to register of companies and he should have gone to the civil court for realization of his money. Why he has come here for the criminal court? Criminal court, my lord, cannot be used for an oblique motive to, my lord, realize the money. Now, my lord, paragraph, then next paragraph is 42 to 46. So, note that 42 to 46. I have already explained to you all 406. That is the case was Sheikh Allah. Now this relates to 415, para 40, 41, 42. Para 40 deals with section 415. What is cheating? Para 41 deals with section 415 does require deception of any person. Two things. Fraudulently and dishonestly inducing that person. This is number one. To deliver any property to any person. This is the second criteria. To consent that any person shall retain any property. Third criteria of 420. Intentionally inducing that person to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage to or harm to that person in body, mind, reputation, or property. Now, para 42 is very important. On a reading of the aforesaid section, it is manifest that in the definition there are two separate classes of acts which the person deceived may be induced to do so. This is number one. In the first class of acts, he may be induced fraudulently or dishonestly to deliver property to any person. The second class of acts, two parts. The second class of acts is a doing or omitting to do anything which the person deceived would not do or omit to do if he were not so deceived. In the first class of cases, the inducing must be fraudulent or dishonest, or there is no material that inducement was fraudulent or dishonest. In the second class of acts, the inducing must be intentional but need not be fraudulent or dishonest. Therefore, it is the intention which is the register of the offense. To hold a person guilty of cheating, it is necessary to show that he had a fraudulent or dishonest intention at the time of making the promise. Promise mere failure to subsequently keep a promise, which I have pointed to your lordship. Subsequently keep a promise. One cannot presume that he alone had a culpable intention to break the promise from the very beginning. That's all. My case is really closed. I've shown your lordship two judgments which are pat on the point. First of all, there is allegation in para 3 of the complaint that I had induced the complainant. Second paragraph, one Rajesh Agarwal induced the complainant and my lord introduced the complaint with Paragon and two others. But he gave the money to two companies and he had invested money to the company. Company was never made a party. Company is a juristic person. And that has been, my lord, taken in details in Sheikh Alam's case. What is the effect if the company is not made a party? And therefore, question of forensic is those. And the ingredients of section 420 are really lacking, and that is rather relevant and evident from this Indarmon Goswami's case, but this is a three-bench judgment of the Honorable Supreme Court. But these two judgments, my lord, goes to the root of the case. Now, my lord, I am just showing the other cases. And these are. Now, next is my Umashankar Gopalika. My lord, paragraph 6.
Paragraph 6.
Yes. Now, the question to be examined by us as to whether on the facts and disclosed in the petition of complaint, any criminal offence whatsoever is made out, must raise offences under section 420, 120B. The only allegation in the complaint, petition of complaint against the accused person is that they assured the complainants that when they received the insurance claim amounting to rupees 4,20,000, they would pay some rupees 2,60,000 to the complainant. Out of that, but the same has never been paid. Apart from that, there is no other allegation in the petition of complaint. It was pointed out on behalf of the complainant that the accused fraudulently persuaded the complainant to agree so that the accused person may take steps for moving the consumer from in relation to the claim of rupees 4,20. It is settled that every breach of contract would not give rise to an offence of cheating. Only in those cases breach of contract would amount to cheating, where there are any deception paid at the very inception. But there is no material to show in the complaint that there is any deception at the initial point of time. If the intention to cheat has developed later on, look at, if the intention to cheat has developed later on, the same cannot amount to cheating. And my answer is there. And next is, my lord, Procedural law. My lord, আর একটা এক্সট্রা কপি লাগার আছে তোর কাছে? এক্সট্রা কপি লাগার আছে? My lord has got 2021 5 Supreme Court cases which I had shown your lordship on the other day.
On the earlier day?
Yes, yes.
Yes, I have it.
Copy lagar. Dena. My lord, kindly, I have got another.
Oh, no, do not please multiply. I'll find it out. 2021,
5 Supreme Court cases.
5 SCC, yes, Kapil Agarwal.
Yes. Para 18.
18.1 and 18.2.
Here is 18.1.
Hmm. Yes.
As observed and held by this court in a catena of decisions inherent jurisdiction under Section 482 and Article 226 of the Constitution, is designed to achieve statutory purpose that criminal proceedings ought not to be permitted to degenerate into a weapon of harassment. When the court is satisfied that the criminal proceeding amount to an abuse of process of law, or that it amounts to bringing pressure upon the accused in exercise of inherent power, such proceeding can be quashed. This is my point. And it cannot be instituted to degenerate into a weapon of harassment. But this is a weapon of harassment. Next is Madhura Sindhya. My lord has got it. This is my lord 98, 88, 1 Supreme Court cases. Madhura Sindhya. Paragraph 7.
Yes, paragraph 7.
Paragraph 7. Now, this is also, my lord, pre-bench judgment. The legal position is well settled that when a prosecution is at the initial stage is asked to be caused, the test to be applied by the court is to whether the uncontroverted allegations as made primarily established. It is also for the court to take into consideration any specific features which appear in a particular case to consider when it is expedient and interest of justice to permit a prosecution to continue. This is so on the basis that the court cannot be utilized for any oblique purpose. Number one, and where, in the opinion of the court, chances of an ultimate conviction is bleak, and no useful purpose is likely to be served by allowing a criminal appeal to continue, the court may, while taking into consideration the special facts of a case, pause the proceedings, even though at a preliminary stage. The chances of conviction is really bleak. Next. Next, my lord, is Ashok Chaturvedi. Para 5. My lord has got the Ashok Chaturvedi.
Have I got it?
Yes, madam. Ashok Chaturvedi. 1998 Supreme Court cases.
Oh, 98 Supreme Court cases. Yes.
This is also quashing of proceeding under Section 406.
Yes.
420, 120B, and forgery. Para 5 minor currency.
But 98, I have got this Madhav Rao.
1998, 7 Supreme Court cases. At extra copy dinner.
Bhajan Lal is here.
Para 5. This is also, can I have a look at the head note? Under Section 406, 420, 467, 468, and 20B. Look at para 5, madam. On the same question. No case has been made out, no role has been played out, nothing else. Last is Bhaskar Chattaraj. 1991, Supply 2.
Yes.
This is also three-bench judgment.
Paragraph 3.
Paragraph 3, right.
Yes.
Right.
Hmm.
That's all. I'm not crowding any more judgment. I'm not crowding your lawsuit with any more judgment. This is good enough for me, I think.
All right.
Last বার ওইটা just ওই যে বলবো না বুঝলো তোমাকে দিলাম তো আমি লাস্টের দিকে ওই যেটা লিখে দিল যেটা Now, my lord, just to conclude here, my lord wanted on the last day directed me, or my lord told me, what is the motive behind it to implicate me in such cases? But after it went to Supreme Court, before that, my lord, there is a civil suit. Your Justice, my lord, Sanjeev Banerjee. At the last fag end of the paragraph of that judgment, his lordship, my lord, in the civil suit, had imposed 500 years fine, my lord, to Rotolal Nehta, who was the original tenant in that house, who I was. Well, I was merely a confirming party to the agreement for sale between Harland and Sureka in 2010. In 2013, my lord, they had implicated me because I was one of the directors of Mr. CG flat owners who had purchased the property. Now, my lord, it had Supreme Court initially caused all those proceedings. Thereafter, again, my lord, remanded back. And in that time, at that time, Vaidyanath Shah, who was the AC ARS, Assistant Commissioner of Police, and at that point of time in 2013, he was the officer in charge of Sexual Police Station. But he was so greedy to the property, he had joined hands with Vishwanath Chaki, another Assistant Commissioner of Police, under whose instruction the charge sheet was hurriedly submitted within 4 days in the last case of sexual assault. And then Dr. Lal Nahata, along with one of my understood child, Momata Agarwal. Who is Momata Agarwal? Well, she is a respectable lady. Well, I am paying respect to the lady. And with respect to this lady, I am submitting that she is an accused of 2 murder cases. এটা দাও না ভাই, চার্জশিটটা দাও না। And therefore, my lord, this is a charge sheet of 398 in which Momata Agarwal is an accused of murdering 2 persons. And therefore, all these 4 had joined hands. One is Vaidyanath Shah, AC ARS, Diden, officer in charge of Sexual Police Station. Second is Vishwanath Chaki. Third is Rotolal Nehta. And fourth is Momata Agarwal, who is very closely related to Rotolal Nehta. I am not saying anything more. And at that point of time, he was the ARS DD. And he, my lord, impersonated. He had impersonated at joint CP, sent a mail. And my lord, that is at page 108 of the main writ petition.
Which number?
My lord, kindly see and
108
of the main writ petition.
5368 or 180? Both.
5368 page number 108 and 109.
All right.
5368.
But that's all of my submission. That's the motive, and that's here, my lord, the motivation of Bujnal Saha at page 108 and 109. And my lord will find it from the charge sheet itself of Momota Agarwal. What she is. Sorry.
Have you annexed the charge sheet anywhere? This Mamta Agarwal FIR 398? No. In that case, this is to be stitched up.
Yes, yeah, sir. On the next day, we shall give to a loss. On the next day,
Next day you can give, stitch it up and then give.
better. Okay.
So you are over? All right.
I'm get to the lordship. My lord is giving present here.
Yes.
May I leave a lordship?
Yes, yes. Now who is going to make submission?
Well, Lord, I shall make submission. I am led by Mr. My Lord, Shishana Bandyopadhyay, the learned senior standing counsel. He will make submission on the other day, my Lord. And if you want to submit, you start, sir. We will start.
Private respondent is not going to make submission today.
Sorry, not sure. Let the state come because let the state finish with the thereafter, sir.
আসুন তো দেখি। Learned senior counsel representing the petitioner concludes submission. Stop. Fix on 22nd for hearing this state. এই দুটোকে এর সাথে ট্যাগ করে রাখবেন। ফাইল করেছে আজকে, কিসে কিসে ফাইল করেছে একটু দেখে নেবেন। Filed in court is taken on record. It will be open for the petitioner to file a reply to the same prior to the adjourned date. Opposition, in case you want to file a reply, it is open for you. And if anything you want to add, then in the reply stage, you can make submission. Yes, call the next one.
For the writ petitioner. My Lord, learned DSG Mr. Dhiraj Dwivedi is appearing on behalf of the Port Trust. He is out of station, my Lord. If your Lordship kindly accommodate a date after 18, or
he can
let
start.
Yes,
My Lord, waiting for a long time. Let him start.
My Lord, I am led by Mr. Obratosh Mujumdar in this matter, my Lord. Let this matter be fixed next week, my Lord. I don't have any problem.
Next Friday is a holiday.
Next year's 18.
Then Friday week it will go.
Yes.
That is 22nd.
22nd.
22nd, this matter will remain on top.
Yes,
You want
yes.
that is continuing.
Yes.
thereafter. So you do not have an urgency now. You are just sitting on the head of the court
My lord, no.
for getting
I
the
am
matter
telling you,
heard.
my lord, I am telling your lordship why there is the urgencies, my lord. First of all, my lord, this is a matter, this is a NIT which is required to be issued in the GEM, e-marketing place, my lord.
It has not been issued.
It has not been issued, first of all. Secondly, my lord, second point is that there is a bid rigging. Bid rigging means, my lord, there are three applicants, my lord, one has become unresponsive. And my lord, that has been considered by the authorities, and my lord, the bid is allowed.
So what remains in the writ petition?
My lord, no. There is a manipulation at the time of bidding. Why, my lord?
The work order has been issued.
Work order has been issued.
What remains in the writ? What you
My lord,
want?
if
Civil court
something
relief is
is
there?
if something is obtained upon fraud and manipulation,
yes,
and my lord, that cannot be looked into by the constitutional court, my lord.
But then this is going to take time. Why don't you go before the civil forum and get everything thrashed out?
My lord, this is not a civil case, my lord. Why I am telling, my lord, subject to correction, my lord, because I am that is first of all, my lord, there the bid rigging has been made as because, my lord, that is at my at the part 3 of my writ petition, my lord. I have annexed the bid summary report where it will be appearing there are 3 bidders and one is unresponsive, and my lord, it will be appearing from the rule 173 of the GFR that if there is no competition, then the at least advertisement should be proper, and the advertisement is in violation of the GFR rule number 159 and 141, which is mandatory, my lord. That is to be followed by all the statutories and, my lord, all the PSUs, public sector
And
and the central government.
The person who is the beneficiary of the bid, has the person been impleaded?
Yes.
And served notice?
Yes. Notice. He is not appearing.
Never.
And, my lord, my lord, the most important thing is that, my lord, the particular it will be appearing from the affidavit in opposition that the port authority filed their affidavit in opposition on behalf of that person, even, my lord. All the respondents.
On behalf of?
Yes.
How can that be?
Yes, my lord.
That may be a typographical error.
That may be a typographical
Then do not
error, my lord.
Did the private respondent ever appear?
No.
Never.
Never appeared.
All right.
It will be appearing from the, my lord, the order sheet of the earlier coordinating bench, my lord. The service was complete. So, my lord, matter is ready for hearing, my lord. I am sufficiently ready, my lord. Let the other side come. It's not that.
No, if you are sufficiently ready, then you please start.
My lord, let the other side come, my lord. I have a senior, even, my lord.
Then do not say that you have a senior and let the other side come. Either you start or you have to wait.
My lord, 20-second, I will start, my lord. 20-second.
20-second, provided you get a chance. Because you mentioned the matter, you got the matter assigned before the court.
My lord, this is actually, my lord, this is not assigned matter, my lord, subject to correction. This is, my lord, your lordship in the monthly list, my lord. And it was mentioned, my lord, and before the...
To be placed before Honorable Justice such and such to consider whether the writ petition can be upgraded and listed in the daily cause list. This is not assigned.
No.
কোথা থেকে assigned লিখেছেন আপনি?
Upgradation has been
Only
made, my lord,
prayer of upgradation has been given.
and that has been allowed by your lordship.
লিখে নিন। Learned Nanan represents the private respondents. Stop. Let notice be served. Stop. Learned advocate representing the petitioner and the learned advocate representing the port both seeks adjournment. Both seek adjournment on the ground of their respective senior counsels. Stop. In view of such submission, hearing stands adjourned for the day.
Beautiful.
Call the next one. The পরেরটা assign না assign নয়
Yes, my lord, assignment.
This is assigned. Yes, please.
My lord, learned senior advocate Pratik Dhar is engaged in court number 26. Can you bring for not today?
Let him start. Who is assisting Mr. Dhar?
Advocate Madhurima Sarkar. She is
Call her. Yes, what is the matter?
This matter, my lord, petitioner, my lord, is the originally organizing teacher in the year 1992, my lord.
Organizing teacher where?
In a madrasa, my lord.
All right.
Then, my lord, staff pattern of the madrasa, there is a more staff. Then, my lord, finally, as per my lord, division bench order of the Honorable High Court, some teacher was permanent. And the rest are those, they are not the party in the said writ petition, so they individually raise their grievance. So accordingly, in the year 2003, this petitioner approached before the authority. At that point of time, there is no vacancy, so Secretary of the Education Department passed an order that at this stage, case of the petitioner is rejected. Only at this stage. That means that, my lord, when the vacancy arises, he will be considered.
That he will be considered in accordance with law.
Law, my lord.
Yes.
Then, my lord, 2009, this petitioner filed a writ petition
Yes.
before this Honorable High Court. And, my lord, Honorable High Court passed an order, that is, my lord, page 69, the writ petition.
Yes.
May I read, my lord, second? The second page, my lord, middle paragraph, drawing attention to the page 9 of the interlocutory application. Decision of the Principal Secretary Minority Affairs Department, June 10, 2009, submitted that one Sofikul Islam was a similarly placed candidate as that of received approval of the post of teacher in the said relevant madrasa. A learned counsel, the petitioner being the similarly placed, got their identical relief, so that of Sofikul Islam. Then, my lord, page 92, my lord, writ petitioner claiming prayer for approval of his appointment. To the writ petition upon giving at least 7 days prior hearing notice. Enter exercise. Then, my lord, while deciding the issue, Secretary West Bengal Madrasa Service Commission shall also consider the said document of appointment of Safiqul Islam dated June 10, 2009. And it
What is the error in the order?
Then, my lord, impugn order.
Yes, what is the error? It has been mentioned there is no provision for regularization of organizing teachers. Where is the error?
No, my lord, 2009, my lord, one organizing teacher has been, my lord, regularized.
Yes. Under which provision of law?
My lord, at that point of time, there is no, my lord, authority considered as my lord, the representation file. Accordingly, my lord, he has been considered. And my lord, 2003, when I, along with other teacher, applied, my lord, for regularization, then one of the teacher has been regularized.
The law for regularization? What is the law? Does the Madrasa Service Commission, this act, this Madrasa Act, does it provide for the regularization? It doesn't. Then where is the error?
They should note that they has no power to regularize. They are rejected that 2003 case of the
No,
petitioner.
page 76 is the impugned order. It mentions, see, there is no provision in the act and the rules for regularization of organizing teacher. Where is the error in this. The act came into existence in 2008. Whatever happened prior thereto is something different.
मतलब 2000 act मतलब 2008 effect तो मतलब 2009 मतलब how मतलब similarly placed teacher has been मतलब regularized.
Suppose somebody has given some benefit incorrectly, inadvertently, illegally. Can you claim negative equality?
No, मतलब petitioner is the मतलब similarly placed teacher.
You cannot help
So
it.
मतलब he can मतलब approach the authorities as similarly placed teacher.
I do not see any error in this order.
They does not say that Sofiqul Islam was appointed illegally or wrongly or not permitted. That they does not show here.
Nobody has challenged the appointment of Safiqul. Then this is not your challenge. Your challenge is that I should be regularized.
When the writ petition was hard in the 2009 writ petition, they do not object that
2009 writ petition was only for consideration of your case for regularization. The act has come into play in between. And now, once the act is in place, they have to act in accordance with the act. And there is no scope. Please come.
that other region they have stated only 2003 rejected. So as similarly placed has been your lordship first order the initially passed the order to take a report from the Madrasa Service Commission. They have filed report. They have not stated that rule does not permit. They have stated that 2003
Page 76, I can see this.
Is during the period when petitioner is appointed by the managing committee of the said madrasa. That appointed in the year 1992.
Yes.
So organizing teacher should not be regularized. That is not the law.
Show me the law that he has to be regularized. There is no law. Please come.
When the Umadevi, after the Umadevi judgment.
No, sir, you cannot take or stretch Umadevi to that extent.
Petitioner will be remediless. Then approach
the petitioner is aggrieved by the decision of the West Bengal Madrasa Service Commission in not accepting his prayer for regularization as organizing teacher of a non-government aided madrasa. Stop. The petitioner claims to have been appointed in the post of assistant teacher in social science group by the managing committee of Vishalakshmipur Puna Shaha Mostania High Madrasa, page 75, স্কুলের নামটা দেখে নেবেন. With a resolution dated 1st October 1992. The case was taken up for consideration. Now, the case of the petitioner was taken up for consideration in the year 2003. And on consideration, the Principal Secretary, School Education Department, West Bengal, taken up for consideration. কি বললাম?
Taken up for consideration in the year 2003.
Along with two other teachers, namely Safiqul Islam, Saficul. No, done. Along with
there is no Sofiqul Islam. There is other two teachers.
The other two teachers, namely
Kallan Maiti and Bonolata Ojha.
Bonolata Ojha, two others, nothing June. Bonolata Ojha, Srimoti Ila Jana, and Joydev Ghosh. Srimoti Bonolata Ojha. Are they similarly placed? No vacancy in the Joydev Ghosh is in the social science and physical Education, work education is Bonolata.
Paragraph
Page-
11 of
page 44.
our commission's report, we have
Yes.
indicated they are not similarly circumstanced. But one thing, my lord, that's
Yes.
require. I'm sorry, my lord, there was a
Mm.
very young judicial officer's pro bono matter was there. I couldn't.
Mm.
My lord, the commission has been somehow added as one of the parties.
Where?
In this proceedings, probably because once commission is constituted,
Yes.
well, we don't have any power.
We means you are.
This commission, Madrasa Service Commission,
Yes.
that is only for selecting, recommending.
Yes.
Possibly in an earlier occasions, a submission was made as if there is a change of law. Now it would be done by the commission. That was incorrect completely.
Mm.
Whether in his case, the government will decide to regularize or approve, commission has no role. Whether it is SSC or the Madrasa Service Commission, my lord.
No, but then I am going by page 76 where it has been mentioned that under the act there is no provision for regularizing.
Yes, true. And
So
lordship,
why should the court go into all these things?
no need, lordship. I just thought that no need. Lordships on the last occasions wanted a report from the commissions indicating whether the petitioner's case is identical to someone else.
All right.
In paragraph 11 of our report, we have categorically stated not similarly situated.
Lord, then my lord, my prayer is, my lord,
petitioner was taken up for consideration. The other.
No, it was taken up for
my lord, may I
consideration.
permit, my lord?
Yeah, actually, I do feel he has a somehow, it's not a good case actually. Your client should know it.
No.
He was fighting for maybe long time, but
the prayer of the petitioner was not accepted. Stop. Paragraph. নামগুলো কেটে দিন. In the impugned order, the commission has clearly mentioned that there is no provision in the West Bengal Madrasa Service Commission Act, 2008, and the rules framed thereunder for regularization of organizing teacher of non-government aided madrasas. Stop. The petitioner asserts that in the year 2009, even after coming into effect of the Act of 2008, regularization of one Safiqul Islam was made by the commission. Stop. Paragraph. The commission has filed a report.
firstly, we never did so. In paragraph 11, we also
affirmed by the Deputy Secretary cum Law Officer of the Commission, wherein it has been
paragraph 11,
page
17.
Mentioned that the case of Safiqul Islam and the petitioner are not on the same footing. Safiqul Islam, Safiqul Islam joined as assistant teacher in the year 1991 against an approved vacancy. Stop. The petitioner was never appointed in any regular vacancy. Stop. He was appointed by the managing committee as assistant teacher in the subject of history. Stop. Paragraph. Admittedly, under the Act of 2008 and the rules framed thereunder, there is no provision for regularization of organizing teachers. Stuff. Next. The petitioner has not been able to show any law in support of his prayer for regularization. Stuff. Next. The It does not appear that
Oh, that's not.
the
my lord.
petitioner
Madhavi
and
judgment, my lord,
Safiqul
I have a
Islam
copy of the Kesri judgment.
stand in the same footing. Stuff. Next, in view of the above, the relief of regularization sought for by the petitioner cannot be allowed. The writ petition fails and is hereby dismissed.
Or then my lord liberty to approach the my lord authority.
Which authority?
Or if my lord
Under which law?
has no
Under which law? Show me the law. If the commission is not there, some department will be there.
as per my lord judgment of the my lord Supreme Court, my lord organizing staff may be my lord regularized. My lord kindly see. Kindly see the my lord Supreme Court judgment. State of Karnataka versus my lord ML Kesri.
ML Kesri. Please do not bring all these things. ML Kesri. How will ML Kesri apply over here?
Not like that. My lord regularize, my lord there is no bar. When my lord I apply, my lord there is a bar.
History went to Supreme
No.
Court division bench.
How they are
Based on that
how
others
how
got
they are different their regular vacancy.